Hi, y'all. Well, there are not many boring days at trial, but for sure, today has not been a boring day in the Ashley Benefield murder trial. It's also known as the Black Swan murder trial because of her career as a ballerina. It was a wild day. The state rested after just practically nothing. And then there were very unusual, very hard hitting closing arguments. The defense repeatedly called out the prosecutor by name, and there were very different views of the people and the events involved. We're going to go over those closing arguments. Actually, tonight we're only going to cover the prosecution closing argument, but we've got so much more to cover. There has already been a question from the jury. They're already back with a question, and they are not gone for the day yet. In fact, they ordered food, which may mean they are buckling down to decide this case tonight. We may have a verdict during this live stream. We are a very short time away from finding out whether this jury says that Ashley Benefield is a victim of DV or a cold-blooded killer. Ashley Benefield shot and killed her estranged husband, Doug Benefield, 30 years her senior. The two sides do not agree on much, but they do agree on that. The state says she was upset because he was trying to get custody of their child, and she wanted the child all to herself. Ashley Benefield says she has a history of DV with her and his first wife, that he has a history of DV with her and also with his first wife, that he was coming for her in her own home and that she shot him in self-defense. Now, were they getting divorced? Were they reconciling? Were they moving together to Maryland, from Florida to Maryland? Did she want their kid all for herself? All of that is up in the air in the case. The sides do not agree on that. So, hi, y'all, and welcome to tonight's live stream. We have a ton to cover. So I want to jump right in with a quick thank you to the first 5 in the chat: Michael Lalonde, LMA1, aka Sue, Susie Q, Melody Perkins, and Rita Young. And if you would, please be sure to hit the like button. That'll really help the video get out to more people. I'd appreciate it. And subscribe if you haven't already joined our crew. So we started with the prosecution in rebuttal, and it was really short, possibly the shortest rebuttal in the history of court trials. Eva Benefield, the daughter of the decedent, of Doug Benefield, 15-year-old daughter at the time, I guess she would be older than that now, but she testified to just 3 things. That's it. It took, I would say, definitely less than 5 minutes, maybe substantially less. She said that her dad was right-handed. She identified a 2018 photo of her father appearing to, quote, appearing to do a push-up, whatever that means. And she identified an August 2020 photo of her dad on a boat. So that is all that the state did. And then they rested just all over like that. The judge gave the jury some time off while he discussed jury instructions with the attorneys. That took several hours. And he also showed them what the verdict form would be, got approval of that. And I want to talk with you about what the verdict form is right now. It is going to ask the jury, we the jury find as follows: check only one, it must be unanimous. So, and they tell the jury check only one. Such a difference, right, from the Karen Reed case. The instructions were so much clearer here in terms of what the jury should do. I thought it made it pretty easy for the jury to figure out, as opposed to in Karen Reed, where, as we know, the jury ended up believing that they couldn't decide on one, and therefore they didn't turn in their response, their unanimous agreement on the other 2 counts. So here's what the jury will be deciding. First, guilty of murder in the first degree, or, not and, guilty of manslaughter, a lesser offense, or not guilty. Those are the 3 choices that the jury has. But there is more to it than that. If the jury decides on one of those first 2, guilty, it also has to answer more questions. It has to answer Did Ashley Benefield actually carry a firearm? Yes or no? And did Ashley Benefield discharge a firearm? Yes or no? And did Ashley Benefield, as a result of discharging the firearm, cause the death to Douglas Benefield? Yes or no? Now, you may be wondering, why those extra questions? Why not just say guilty of murder, guilty of manslaughter? Why are we dealing with this extra information? And the answer is this: because Ashley Benefield will receive a sentence that could be different based on the jury's answers to those additional questions. If she carried a firearm, discharged a firearm, and the discharge of that firearm caused the death of Douglas Benefield, if they answer yes to those, then what may happen is that she will have an enhanced sentence under Florida law. And if it's guilty of murder in the second degree and it's enhanced by discharge of a firearm, it could be a mandatory sentence of 25 years to life. So there are enhancements that are required by the court. The court has no discretion to lower that amount. Now, so we will wait and see whether or not they have that and what amount it will mean for them. But it's definitely an important question. Now, before we dive into what exactly the prosecution talked about, and that's what we're going to cover tonight, we're going to cover the defense closing argument tomorrow night, because it was just so dense and there was so much of it that I didn't feel like I could do them both justice in one live stream. If it turns out really late and we're waiting for a long time, then it may be that I regret that decision. So first of all, let me say thank you to Melody Perkins, who's been a member for 4 months. What a nice comment. Best court analysis podcast on the web. Thank you. I really appreciate that. And I'm glad to have you as a member for 4 months. We've also got Terry Webb as a new member. Welcome, Terry. And Michael Lalonde, I appreciate your super chat. Thank y'all, all three of you. Thank you very much. Okay, so let's talk a little bit about the jury question that came out, because we've already had one and it was super interesting. And I think it was good for Ashley Benefield, but it's hard to tell. And I'm going to explain why. So here's the question that came back. Dr. Quintal testimony defense recall. What they mean is the defense recalled a witness the prosecution had already had. Dr. Quintal was a prosecution witness and they recalled him. He was a counselor, psychiatrist who had worked with Ashley and Doug as they discussed whether they could reconcile in their marriage. They were talking about that. They were trying to work through marriage issues. And so his question, he was the person who did actual counseling with them. So here's the question. Was his, and they're specifying not what he said in what the prosecution brought him for, but what he said when they brought him back. So they're remembering something specific that he said. Here's the question. Was his description of Doug based on his observation or what Ashley told him, i.e. domineering, super controlling, alpha male, over the top, not genuine? They asked all of that. I'll read it again because it's real important to get the details. Was his, meaning Dr. Quintal's, description of Doug based on his observation or what Ashley told him, i.e. domineering, super controlling, alpha male, over the top, not genuine? Because he had said all of those things about Doug Benefield. The huge question here is whether or not Ashley Benefield had a reasonable expectation or reasonable fear that Doug Benefield might be going to attack her. She says she did, that she believed he was going to attack her, that he might harm her, and that's why she shot him, and she shot him in self-defense. So that's her argument. So this question is, why did he say that? Was it based on having met Doug? Or did he really just get that from Ashley? The prosecutor had pointed out that he met primarily with Ashley. He met 5 times with Ashley and only twice with Doug. He also met twice with the two of them together. So he had more input from Ashley than he did from Doug. So the question then is what are the things he said about Doug, because they were very harsh, very, very harsh, that he thought he was an alpha male, that he was not genuine in his religious beliefs, he was domineering and tried to control Ashley. Are those things something that he just picked up from Ashley because she complained about Doug so much? Or did he really truly form those opinions about Doug? And so the defense said, well, you need to read back the testimony from yesterday. And because the defense says, he said it was based on both of those things, and it was included based specifically on having met Doug and what Doug said and what Doug did. And the defense said it's going to be prejudicial to us if you don't read back the testimony, because this is a really important point. And I brought him back to ask that question. So the judge said they didn't ask for a read back. They didn't ask me to give them exactly what the jury said. And so that's not what I'm going to do. And the defense said, look, they may not know that's possible. They may not have known to ask for that. What they're trying to do is get this information. So figure out a way to give it to them. But the prosecution and the judge said, no, we're going to go with the standard instruction, which is use your memory. It's just a standard instruction that says if you have a question, you should rely on your memory, talk to other people, see if anybody wrote it down. Actually, you're supposed to go off your memory, not just your notes. But is there an answer to that? And we're not going to tell you the answer. I think that's sort of a shame because they had a very specific question, and I think the defense had a point. I wanted to read you a little bit about what was said yesterday about this very question. And this actually came from the prosecution part. I only had a little bit of time to find the answer for you right beforehand. So there will also be some questions about this from the defense. But so here is what the question was. You said you met with Ashley Benefield alone 5 times, and you met with Doug Benefield alone twice. And he said, yes, ma'am. And you met with them together twice. Yes, ma'am. This is the prosecutor asking these questions. So the majority of the time you met with Ashley Benefield, over half of the times you met with her to do trauma resolution. Yes. Yes, ma'am. And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not? Yes. They were comments that she made and frustrations that she had within the system, okay? So it was not solely, and here's the final question from her. So it was not solely based on things that you were observing in Doug Benefield. No, ma'am. Okay, thank you. No further questions. So I think that comes out in the defense favor, because what they're saying is, okay, yeah, it wasn't based solely on that. It wasn't based 100% on that, but it was at least based in part on that. And that's pretty important. What had to have been happening is people got back in the room back there, and they were talking about, well, Doug, somebody said Doug was really domineering, alpha male, really controlling. No wonder she was afraid of him. That means somebody on that jury is taking Ashley Benefield's self-defense claim very seriously. They brought out all of that for the other jurors to hear. Okay, so that's one side. But somebody else must have said, well, he just got that from Ashley because she met with him a bunch, and that's where he got that. It wasn't based on having met Doug. It was based on just what she said, and she's very manipulative. And the two groups or two people, one person on either side, it's impossible to know which. And that's what makes a difference, because we don't really know whether this was from the direction of one person saying, hey, wait a minute, I'm pretty sure Dr. Benefield met with Doug, that the doctor met with Doug Benefield and thought that Doug was real controlling. And somebody, and the whole rest of the group said, yeah, but that was just from Ashley, and she's very manipulative. We're about to convict her except for you. Or whether it was flipped the other direction, whether the majority of people were saying, no, this seems like she had a real true self-defense, and one or more people We don't know how divided it is, but it sounds like there was a real split among them over this issue. And this issue would help them resolve it. Either way, somebody on that jury is seriously considering her defense, and somebody on that jury is seriously considering the prosecution claims. And they've got to figure that out. So we know that it's going to be a hard fought issue. This was I always talk about these messages from the jury, these questions as being clues, because they are. And lawyers will spend hours talking over these. There's nothing else coming out, right, during the middle of trial. So everybody sits around talking about, what do you think that meant? And you'll have rehashed it multiple times, and someone will say, well, back to that question, what do you think the jury meant when? And everybody wants to know, because you're sitting out there with no clue as to what the jury is thinking, doing, saying. It doesn't really matter in the sense that you could do anything at that point as a lawyer, but everybody is interested, and it is important. It does give people an idea of kind of where the jury is leaning. And what this tells us is they're not sure. There are people on either side of the issue. They thought this particular question was important. So that is, I thought, a very important question. I was really intrigued by that. So let's talk next. Let's go ahead and get into what the prosecution did as far as closing. Now, there's a lot to cover. They were really well done, I thought. We're only going to cover the prosecution opening. As I said, we'll do the defense tomorrow night, 7 p.m. Eastern at our regular time. I thought both were fantastic. I would maybe rate the prosecution a little higher than the defense, but for a reason that might surprise you. The reason was that the prosecution organized and put together the case in a way that, frankly, they had not done up until that point. And by far the best we've seen in a while, in terms of just, here's a timeline, here's some organization, here's what you'll be deciding, here's where all of these things fit in. And they hadn't really done that up until then. By contrast, the defense had pretty much done what it needed to do. The defense had made its points fairly cleanly and clearly. So I thought that the closing was fantastic, but it wasn't as transformative. It just explained to you what they have been saying throughout the trial. So that's why I would rate it a little higher, but they were both absolutely great. They were organized, tight, and neither of them was a truly emotional closing. Some lawyers are really known for that, bringing the jury in with a lot of emotion. Neither one did that. But what they did do was explain what the jury should decide and how they would make the decision. That is so, as we watch closing arguments on all of these cases, I see how unusual that is and how important it is, because it really helps the jury make the decision. So let's pop up some of what the prosecution said. The first thing out of the box that the prosecutor said was, look, DV is real, but that's not what happened here. And so that was the first thing out of the box that she said. But she adds this.
A valid point, but not for this defendant. This defendant used
DV
and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs.
So she admits right away, because it's the elephant in the room, right? There are people, no doubt, on that jury who either have had some DV in their background or know someone or are related to someone in that situation. In our chat right here, we have numerous people who have that background. This is something that they themselves have personally suffered. And so what she's telling them is, that's not fake. There's no putting that aside and pretending there's no such thing in the world as DV. We're not going to pretend that. But what we're going to say is, in this case with this defendant, that's not what happened in this particular case. And so the goal was for her, she wanted sole custody. The goal was never about actually preventing DV. She was never really a victim. And that's in a nutshell, what the prosecution argued about her. And now she's going to talk about the two key words in those jury instructions that she wants the jury to focus on during their discussions. I want to say thank you to Sky Goddess for your nice super chat.
That self-defense instruction, it's called justifiable use of deadly force, is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did.
And that's what she's going to talk about throughout, weaving it throughout her closing argument. She's going to say, here it wasn't reasonable, here it wasn't necessary. Ashley Benefield shot Doug Benefield, and there was never a need for that. There was no justifiable reason for that. It was just something she did. So she also talked about the fact that the fear that Ashley Benefield claimed she had made no sense. While Doug Benefield may have done some things to her, it had been 3 years. He had done absolutely nothing with her, to her, with her, negative in 3 solid years.
The state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. But he also apologized for it. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between.
And the prosecution throughout said, look, if the guy hasn't done anything for 3 years, then all of your pretense that he had, all of the efforts you made, like filing for an injunction, that obviously wasn't motivated by real fear, not by real DV. Obviously, there was some other purpose behind it. And here's where she's going to make that argument.
She filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against. It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. She starts as...
So she also argued, the prosecutor did, that Ashley Benefield's allegations against Doug Benefield were just unfounded, that she made claims that not only were not supported and not found to be real by law enforcement, but that they were just fundamentally false. And that was why she kept getting knocked down by law enforcement, because she was trying to make up allegations against Doug.
Series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child. She files for a new injunction in Florida based on all of the same things in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. When she goes reasonable,
and that was a theme. Oops, darn it! I hate it when I do that. So that was a theme throughout. I'm going to start that. Stop it right there. So that was a theme throughout, is that she wanted law enforcement to support her. She kept going to them. Both sides made this argument, by the way. The defense was, look, no one was listening to her. This is a classic problem with people in a DV situation, is that the establishment won't listen to them. But the prosecutor says they're not listening to her because she's making up fake stuff. Like, he sends her a birthday gift of tea. She doesn't like the smell of it, and she accuses him of trying to poison her. That's crazy talk, is what they say. So at this point, she also talks about, and we'll hope I can find exactly where we are in our description here, but that she excludes Doug Benefield from the birth of their child. She splits up with him, goes to Florida to be with her mother during her pregnancy with their child. He had had his vasectomy reversed. The two of them had wanted a child, and he had his vasectomy reversed. She became pregnant. She wasn't feeling well. She went to be with her mother. He drove her down there and said, according to her, that he didn't have the time to spend with her, nursing her since she was sick. So he took her to her mother. So she's in Florida. He's in South Carolina where they met. And at this point, she's pregnant, and he actually they have an injunction, mutual injunction against each other where they can't be in touch because they are splitting up. And he has a lawyer write, well, tell me when the kid's going to be born. I'll do anything. I want to be there. I want to be there when the kid is born. But she intentionally excludes him from the birth of their child, is what the prosecution is going to argue here. Let's see how close I can get to where we were.
Born. Then for a new injunction in Florida based on all of the same things in South Carolina. And when she
only
went
a
to law
sentence away,
enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. When she goes
here we go
early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, didn't know this child was born. Then she does not put his name on the birth certificate.
And the prosecution argument is this is not a guy who was trying to abandon his wife and child. He wanted to be involved, and she intentionally excluded him. She wanted full control over their child. She didn't want him involved at all. Later, of course, there would be an actual claim for that, but probably the showpiece of evidence for the prosecution is a very controversial set of statements that Ashley Benefield made to Detective Gillum. He testified about that at trial. The problem with it is that he didn't write it in his initial report. He didn't say these things until 2.5 years later. And the defense says, why wouldn't you write something really critical like this in your report? So here's what she said to Detective Gillum, and it is explosive. It is definitely a game changer if the jury believes it.
And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive, it is her plan, it is what she did everything for. He said her true motives were to use the criminal system to affect her family court case, to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, "If the judge sees him arrested, it will help me keep my baby." She wanted him arrested in family court in front of the judge and made that very, very clear. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs. She also said to him, "You will arrest him in front of the judge, and I will make sure that you do." Then she said, "I will do anything I have to do to keep my baby."
So that was my attempt at adding a beep. It's my very first time adding a beep. I've tried to do it in the past unsuccessfully. I'm not sure it was super successful there. But anyway, there were words in there that are YouTube unfriendly, and therefore I bleeped them out. We try not to do that here on the channel. But she, very explosive comments if they were made. If she says to him, "I want you to arrest him in front of the judge because it will change our custody dispute. If only the judge sees him get arrested, the judge will surely go with me and let me have sole custody of our child." Of course, that's what the prosecution thinks is the whole thing behind this. The entire reason behind what Ashley Benefield was doing All of these allegations of DV against Doug, all of that was really just because she wanted control of their kid and she wanted to push him out. So that's their argument. And if she made these statements to Detective Gillum, that's extremely powerful. He testified that he didn't see, that he clearly remembered this. It was something that he had never had happen before. There was no possibility that he would forget it. The defense says, look, you claim to remember word for word what she said years later, and you didn't even bother to write it down in your report. What's up with that? So the fact that she kept the child away from him, not just the birth, but continued to keep the child away from him, was extremely important in the prosecution argument.
She kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. So it begins the charade of her telling him, we're going to get back together, we're going to be a family.
That was one of the stranger things about the trial, I thought, was according to the attorney for Doug Benefield, who testified at trial, she was present when Doug Benefield first met his child. She was 6 months old, and the court had said, you get visitation. This whole keeping you from your child is ridiculous. You get visitation. So the attorney is present as the child is to be handed over. But Ashley, instead of saying, here's the kid, Ashley says, tell you what, I'll go with you. Why don't we all hang out together as a family? And the attorney said, look, we've just been fighting tooth and nail in court. This was really strange behavior because she was opposed to him even being with the child, and now she wants to be with him too. There could easily be other explanations. For example, she may have wanted to stay with the child. Maybe she felt like the child would be safer. Maybe she was doing breastfeeding. I don't know what her actual reasons were. And I don't remember anyone asking her during her testimony. But this was important to the state to say this was a strange occurrence. And it's part of her attempt to control. It's not something that was naturally occurring that she wanted to get back together with Doug. She just wanted that kid. After she had tried various DV charges against her, none of which were working and none of which were being actually pursued by law enforcement or prosecution, she then tried DV charges against a child since the charges weren't working as they applied to her, saying that he was engaged in abuse related to the daughter.
So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. He files for divorce. And a series of complaints start against Doug Benefield, which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And to Doug, she's saying, yes, I want to reconcile.
And let me kind of intro this next little bit. The prosecution says she did pretend to try to reconcile with Doug. She went to counseling with him, but all of this was just a pretense. She was doing things behind his back to keep the child away from him. She was preparing an injunction, for example. She was preparing things. She had no intention of actually reconciling. All of this was fake, is what the prosecution said.
Let's get back together. But behind his back to the doctor, she's like, no way, no how. I'm not getting together with him. There is a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough.
Now, what you're about to hear, she said to Dr. Broder, is critically important.
And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered.
So the prosecution says that's what was going on here. She was frustrated that she couldn't get her way with these fake charges, and therefore she decided to, as she put it, take matters into her own hands. And that's what she was doing to get control of the child. This had nothing to do with anything other than that. That was what she wanted. She never wanted to get back with Doug. That was all just a pretense to try to play on his emotions. They even had a mediation in the days shortly before his death. And at that point, they were going to mutually drop his petition for divorce, her request for an injunction. All of that was going to get dropped, and they were going to jointly move to Maryland, where they would co-parent their child, although they weren't going to live together. In fact, on the night when he was shot and killed in her home, he was at her home because she had asked him to come over to help her move, to help her pack things up. They were putting all of their stuff, his and hers, in a single trailer. They were moving more or less together, even though they were going to live separately there in Maryland. So here's what the prosecution says about that mediation where they were going to drop everything.
But they go to mediation, and at the end of mediation, it's very fast because they all agree. We're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction, and she knew that was not true. Her attorney testified, we were not dropping that injunction. That hearing on the 30th, we were going forward. Ashley Benefield knew that day it was going to be over. Her entire charade was going to be done.
Now, this was an important point of contention during the closing. In opening and earlier, the state had talked about the idea that Ashley Benefield did think the 30th was really important, but she thought it was really important because they were about to unveil the report Dr. Broder had done about them, about their relationship. And the idea behind that was sort of an insinuation, without it actually being said, that this report must have been very negative for Ashley. The defense says, first of all, nothing negative in that report. Broder testified there was nothing negative about Ashley. He had nothing negative to say about her. And secondly, they proved, and I think extremely effectively, that no such thing was going to happen on the 30th, 3 days, I think it was, from the time he was killed. That wasn't actually an issue. So all of this was just pretend. There was not going to be an actual hearing where this was going to be unveiled, and that would give her this reason to kill Doug so that she could hide this report. And so if that wasn't going to be the case, then why? What's the motive here for her to suddenly kill him after they've had these months of kind of semi-reconciliation? Well, the state in closing said, well, okay, they didn't mention that earlier argument. Instead, they said this injunction was the reason. That injunction was going to be heard on the 30th. And when Doug Benefield realized Ashley was still going to put that on the table, she was still going to ask for that injunction, it was the jig was going to be up. She was going to have revealed the fact that she didn't intend to get back with him. She maybe didn't even intend to move to Maryland, but she for sure didn't intend to get back with him. She still wanted an injunction preventing him from coming near her, or perhaps even near her child. I don't know the full extent of it. And that was the motive. The defense was up in arms saying, look, this is a brand new motive. You didn't even have this motive before. You had a different motive in opening than you did in closing. Jury, pay attention. This is changing. This shows you that they don't really know. They don't have a viable theory here. The state also really drove home hard the idea that her beliefs that he was after her could not possibly have been reasonable, given the fact that he had done nothing to her for 3 solid years. No threats, no bad acts. Here's what the prosecution said.
They did not live together for 3 years before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they hadn't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no.
And in a nutshell, that is the prosecution argument right there against Ashley Benefield's defense. Now, the prosecutor also talked about the DV wheel that was presented by an expert witness for Ashley Benefield. And for those of you who are noticing, Dr. Ferris presented the wheel. So it was a Ferris wheel as presented. So she went through sort of the things that she went through. It was a wheel with all these different pie pieces that would explain what kinds of control would be used in a DV situation. And she said, none of this makes sense in this situation. There wasn't any abuse going on of any type. And there were no allegations that there was something physical going on, that there was something sexual going on, nothing like that. And when I've cut this way, way, way down just to give you a flavor of what she argued.
Did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. One of the other prongs is using emotional abuse. They weren't together. There was no allegation of emotional abuse. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine, and she even started a new relationship with someone else.
In fact, she had a ring on with this other person. That apparently, according to the prosecution, was when he finally filed for divorce, when she was wearing a ring from another man, an engagement ring, the prosecution called it. So one of the prosecution's best points, I thought, there was I guess you would call it a story. There was a testimony about an event by Ashley Benefield. She claimed Doug Benefield was lurking around her house and peeking in her windows in the dead of night. And she got this from her neighbor. And here's how the prosecutor picked it apart, and I thought it was frankly well done.
Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there, he said he lived there. And somehow this translates to this person is looking into your windows across the street. And the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Would you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really.
So the argument that was made, the neighbor didn't actually see Doug Benefield and say, oh, yes, I recognize Doug. I saw him and knew who he was. She said, I saw a guy in a baseball cap outside, and he said to me, hey, look, I live here. I'm not a risk. And he wasn't looking in Ashley's windows. He was looking in the neighbor's, he was in the neighbor's yard. And the neighbor said, hey, who are you? And he said, I live around here. So that was what happened. It was Ashley taking the recorder over and saying, okay, well, you heard his voice. Does this sound like his voice? And that was the only identifier that made it into Doug. And so the prosecution is saying all this stuff has been made up about someone who's now dead and can't defend himself. There's no real evidence that Doug Benefield lived there. That Doug Benefield was lurking around there and trying to look in her windows. So that's the argument that they're making. And they finish up talking about, the prosecutor finishes up talking about that DV wheel. Again, just little clips I'm giving you.
Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. Using coercion or threats. No threats. She didn't say there were any in those 3 years. None. Ashley Benefield kept his shove from him.
Oh, and let
So
me
if
let me
any
stop it there. So the prosecutor went even further. She did not just argue that Doug Benefield wasn't an abuser. She went further and she said Ashley, in fact, was the one doing things like withholding his child from him. She's the one that a lot of these wheel pie pieces fit, not Doug Benefield. So here's what she argued.
anybody was using power and control, it was Ashley Benefield against him.
And she talked, the prosecutor did, about what some of the standards that they would have to apply as a jury when they made the decision about whether or not Ashley Benefield was guilty. And again, the two charges, murder in the second degree and manslaughter. Those are the two things they'll be considering.
The acts are done from ill will, hatred, spite, or evil intent. Now notice, this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files, fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will.
The real question, the prosecutor said, is whether or not Ashley Benefield really was engaged in a necessary self-defense. Is that an accurate way of talking about what happened here? That's what Ashley Benefield's defense is. She says, she admits she shot and killed Doug Benefield. That's off the table. She acknowledges that she did that. She never argued that she isn't the one. She just said she had to do it because she was afraid. He was coming at her, lunging toward her, doing things with his hands that looked like a fighting stance. And in self-defense, she shot him. That was her explanation.
So the real question in this case is, was there self-defense? Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony.
And the prosecutor is going to say that's not just, it can't be justified based on that because she could not reasonably have been afraid of Doug Benefield. And there's some facts she's going to talk about that explain why she believes that.
Was not afraid, so she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield.
And in a nutshell, that's why her testimony was the make or break. Her testimony was everything in the case. All of the other testimony, all of the other witnesses, the evidence just goes to either support or detract from what she says. That's what, because she's the only one who can talk about what happened in the house. They can talk about trajectories, bullets, wounds, direction, things like that. But that just supports or contradicts what she said. Her testimony is ultimately what will make or break the case, what will convince or not convince the jury. And so the prosecutor went straight for that. And the prosecutor said, look, she was intentionally evasive in what she said. She fake cried. Here's what the prosecutor said.
If questions got a little too difficult or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes? Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break, crying hysterically. Takes the stand right after that. Eyes are just fine, makeup's just fine.
I will say a lot. You hear this all the time in these cases. We heard it in Amber Heard about Amber Heard and the Johnny Depp versus Amber Heard. We heard it about Alec Murdoch. I personally, different people cry different ways. To me, that doesn't really seem all that persuasive. Typically, sure, people get red eyes, they have actual tears, but I just don't think to me that would be all that persuasive. So I am really curious what you think about that because we have it a lot. It comes out a lot in cases that we cover. So if you would put in the chat, what do you think about that? Is crying with actual tears really important to you? If so, put a 1. If you're thinking, not really all that important to me, it's based on other things, then put a 2. Because I'm curious if I'm the only person who feels like this, I may be because it comes up a lot, the question of whether or not there were real tears. So the prosecutor also said she made all these fake claims about injuries to herself in this tussle with Doug Benefield. But in the end, he's the one who's dead and she's got almost nothing in terms of injuries. In fact, the prosecutor will say nothing but 2 scratches on her side, which are inexplicable when it comes to a tussle with Doug Benefield. Here's what the prosecutor says.
She said during this move that Doug bumps her on the shoulder a couple times.
Now remember, they're at her house because he's helping her pack up and they're both going to move to Maryland. That's why he's there.
Body check or something. She didn't really act that out very well. Who knows what that was. Doug.
I have to agree with that. It was kind of like he was doing something with his hands and it was just very awkward. Oh, no, I didn't do that. I didn't do that. Oh, I hate it when I move. There's this little thing. If I hit it wrong, let's see where we are.
Hysterically.
We're going to scoot ahead a little
Bumps
bit.
her on the shoulder a couple times.
Perfect.
Body check or something. She didn't really act that out very well. Who knows what that was. Doug, carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Wouldn't you expect a bruise to be there as well? There's no bruising. They look like cat scratches. 4 people testified that they saw her after this incident. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen.
One of the really interesting side arguments that happened during the trial, the prosecutor managed to put in the actual mug done because the idea is that may make the jury think of this person as more like a criminal if you put in a mugshot. But it was important here and the judge allowed it. They put up 4 pictures. There was a picture taken right after the incident where one eyelid is maybe a little bit bigger, seems a little more swollen. I think I even have that. If we run a while, which we may, if we are waiting for the verdict, which I hope will come out tonight. But if I may pull that up. To me, when you looked at the mugshot, she had the exact same eye, and the mugshot was taken weeks later. And then they put up 2 other pictures too to say, look, this is just the way her eyelids work. This is how they look. It's not something that happened right when Doug Benefield supposedly attacked her. So this was all fake. She had no injuries. And therefore, the prosecution says there wasn't a fight with Doug. She just shot him in cold blood. It wasn't that he was coming at her or attacking her. And speaking of, the prosecutor said, look, she claims he was in this fighting stance, but her testimony doesn't match the direction that the bullet went. Here's what the prosecutor argued.
And determine for yourselves, use your common sense, which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away.
So he was right-handed.
So he's right-handed. He's in a fighting stance. He's going to be like this. Interesting because he's shot from this side. So he's like this. And then she says he lunges at me. Right? So if he lunges at her, he's head on. straight onto her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went. That bullet went side to side. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. To believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him.
I thought those exhibits were really helpful to show where the trajectory was and that it was more of a side-to-side issue. So it was sort of just a practical argument that the prosecutor made here at the end of the case, not one that was necessarily clear from what the witnesses said, but one where she pulled it together and said, look, if this is the trajectory, if this is the way the bullet went, then he can't have been coming at her and then Ashley shot him from the front. That's not possible. She also talked about the fact that Ashley Benefield never really seemed concerned for Doug after she shot him. Here's what she said.
And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. You know, I had to do it, but somebody help him. Not once.
Now, Ashley Benefield was, as the neighbor described, hysterical. She was extremely upset. People walking by, also neighbors taking a walk there, also saw her come running out hysterical. So she was upset. I don't think the prosecutor has an argument to say she wasn't upset. The question the prosecutor is raising is, why not ask for help? Why not ask for help for Doug Benefield? She never did. Instead, the neighbor is the one who called 911. So the prosecutor ended with this, he never came at her argument.
Remember, the defendant sat right there and said the defendant never punched her ever. Never choked her, never kicked her, never came at her with a knife, never came at her with a club, never came at her with a bat. And she was the only person armed in that room. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder.
That was where they ended. That was how the prosecution ended. Now, following that, there was an entire argument from the defense. Excellent argument from the defense, which we will cover tomorrow night at 7 p.m. Eastern. Additionally, there was then a rebuttal from the state. That one was much more generic, and a couple of things in it I thought were maybe even possibly off-putting for the jury. But the first two particularly were really strong. I thought both of them were excellent arguments and in a different style. Some lawyers do really flamingly exciting, dramatic closing arguments. Neither one was that, but they were powerful in a quieter way, putting together the evidence and making clear, concise arguments to the jury. So I am now looking for your questions, and what will help me spot your questions is if you put some question marks at the beginning so I can know, I can spot yours in the middle of the chat. That will really help me. So I want to go through and I'm curious what y'all have thought about the case so far. I can't do a poll on this streaming service that I use. So I'll just have to look for your questions, and then I'll ask some polls using 1s and 2s to kind of give us a way to communicate. So, okay, I see some people agreeing that they were great closings. I see several people agreeing with that. I really did think they were. I was really impressed, and I thought it was nice to see such clean, crisp closing arguments, they were reasonably long, but they weren't tedious, and they really marshaled together the evidence and explained to the jury. I can't tell you how great it was, how refreshing after Karen Reed to have the judge also gave very clear, easy to follow instructions and said, here's your verdict form, pick one of three. Isn't that's just kind of useful information if you're a juror. And I felt like I thought it was great that he did that. Now, the jury is still out. We are still waiting for the jury to come back, and they are out. They ordered dinner in. The judge said it's not going to be steak and lobster, but we can get you pizza. And so they've ordered, and we are expecting, if they waited this late tonight, I would not be at all surprised to see them actually have a verdict tonight. So I know that the lawyers are frantic with nerves. And I know that Ashley Benefield is as well. And the jury is in there just knocking it out, trying to figure out how they're going to decide this case and whether they can decide this case. So I would also think if they were so deeply divided that they did not think they could possibly reach a result, that they would have gone home for the day and said, let's just start over again in the morning. That's what we saw the Karen Reed team do, or jury do. We saw they were just, okay, we're going to stop for today. We'll start again tomorrow. And the judge sometimes said, okay, we're just going to break and everybody kind of regroup, think about things, and come back tomorrow. Maybe we can get it done. So that's my guess, is that they're in the ballpark of close enough to decide. That's my thinking about it. Okay, so I'm looking for the question marks. M. Meyer wants to know how fast my hair grows. It does seem like I'm like, I just got my hair cut. What the heck? So I don't know, but it does seem terribly fast to me too. Shiroshina, how long do you think the jury might be out? Well, I guess I kind of just answered that. I think the fact that they're still back there means that they have some hope of reaching a resolution tonight. I think if they had zero hope, they'd just call it a night. They have to stay reasonably long after they get the pizza. Otherwise, it looks bad. And I think the pizza was coming, did I hear 7:30? I don't know where I picked that up. But so they have to at least make some effort to work through dinner. They can't just be like, oh, thanks for the pizza, we're out of here. So give them a little time, but I don't think it'll be too long. Did you agree with how the judge handled the jury's question? Denise Pelton asked me. I honestly did not, and I hate to even say this. This judge is fantastic. He is absolutely great. A judge's judge. He argues, thinks through, ponders every single decision. He's great. I think he's doing a fabulous job. This is about the only thing I can even think of where I did feel like it was a little bit unfair. The jury asked this question that could have been resolved by hearing from the transcript. And he said, yeah, but they didn't ask for the transcript. Okay, granted, they didn't ask for the transcript, but they may not have known that they had that option. Instead, they just said, what did he say? And it could have been resolved by reading the transcript. So I did feel like I would have answered that question and said, I probably would have said, I can't answer that. You may ask for the transcript. If you believe that would be important to you, let us know. But it's not necessarily something that the jury might just know. And the defense objected and said they may not know that, and you may need to tell them that. But the judge went with the traditional instruction that is given to a jury when they ask a substantive question like that, and you tell them, a factual question would probably be a better way to describe it, and says, you're the ones who decide fact. I can't tell you those things. Go talk amongst yourselves and see who can remember what was said. Obviously, they had some kind of disagreement. One or more of them were thinking that this question would support Ashley. One or more of them were thinking this question would support the prosecution. And we don't know exactly where they fell, but where they fell would tell us how the jury is split and what the likely outcome will be. We'll cover that again in just a minute for those of you who are just coming in, but let me go through some more of the questions for now. So Spence wants to know, if she's found guilty, what sentence would she potentially face? But Spence is saying, kind of voting on the not guilty side. So Spence, if she's found guilty, then what I saw today, full disclaimer, I am not a Florida lawyer. I don't pretend to be able to to be able to answer this question, but this is what it looked like in my research. The judge referred during the discussion yesterday, he referred to the enhancement under Florida law. And that enhancement makes it a requirement that the judge impose a mandatory sentence if the person was using a hear me. Can somebody put it? Oh, I'm back. We've got bad weather in the area, so hopefully that won't continue to be a problem. But but as what was I talking about? Oh, Spence's question: what kind of penalty? So there is a mandatory sentence if a firearm was used. There are specific questions on the jury verdict form that relate to the use of a firearm, and the mandatory sentence for murder in the second degree would be 25 years to life. And so the judge would have no option of giving her 15 or 10 or 20. He would be required to give 25, is what it looked like to me, if the enhancement is found by the jury. And I don't see how it could not be. She admits she was using a firearm. The big question is, was it murder or was it manslaughter? Not whether she was using a firearm, because she was. So I don't see how they don't find that enhancement. Now, the manslaughter could carry a sentence of up to 15 years from what I saw. Again, not a Florida lawyer. I'll defer to them on that. That was just what it looked like to me. Susan Moore was asking about, I couldn't figure out the talk about burglary. Wasn't that very confusing? So there was talking about, okay, there was possibly a burglary. Here's where that shook out and why they were talking about it at all. One of the issues was Doug Benefield was in the house at Ashley's request. He was helping her move. She was allowed to stand her own ground. There's that statute in Florida, but she was also, and that's true anywhere, not just in your home, but you have a special right to stand your ground in your own home. If the person is not an invitee, someone that you wanted there, then that person has to leave if you want them to, and you're entitled to defend yourself and your property in your own home. If he stayed after she told him get out, and she testified that she did. She testified he started arguing with her. They were having a fight, and she's like, get out, and he didn't. At that point, he became no longer invited, and at that point would have been a burglar in her home. So that, and not necessarily stealing property, but in her home, uninvited, and obviously with some kind of ill intent in her mind. So that was what that was about. And anyway, so there you have it. Patty, women against women, both good. I'm not sure exactly what you mean. You may be referring to the fact that the prosecutors were both women, and of course the defendant was a woman. At one point, there was even a comment about that made today in the rebuttal, because one of the two prosecutors, we rarely heard from her during the case. Most of the case was handled by the other prosecutor, but this particular prosecutor did the closing rebuttal of about 40 minutes, and she said, they've argued that there was this old boys network, and they were all in favor of Doug Benefield, and they were against Ashley. And that couldn't possibly be the case. Look, the prosecutors are female. So that was one of the things she argued during that time. So Graciela says, do you think having unsecured guns in a kitchen basket, bag, etc., is not crazy? Graciela, that really bothered me. She had a toddler, a 2-year-old, in the home there. And she testified that she had a laundry basket and the gun was sitting on top of the laundry basket. And there was another gun in the closet and loaded. She simply picked it up. It's already loaded. She shoots him. That just gives me a heart attack thinking of a little 2-year-old who might have gotten hold of that gun. So yeah, it seems a little crazy to have had that sitting around. Maybe they were in the middle of moving and you do all kinds of crazy stuff while moving, but ooh. Thomas T, did you watch the prosecution rebuttal? Yes, I did. We'll have to cover that another day too. But there was a lot here. I thought the strongest one, the most important one, was the prosecution, and then of course tomorrow we'll cover the defense. But we may be able to go it. We may be able to go to it. So, Justice Scales, imminent threat to life, asking the question, and I think referring to the fact that that's one of the issues that will be decided by the jury. Mark Chandler, generally, which witnesses are allowed to sit through the trial? That really varies depending on the state. Some states allow family members of victims to sit through. Sometimes the family members of the defendant might be allowed to sit through. And typically someone who's already testified and is through with their testimony will be allowed to sit there. But it really varies. One of the things I'm sure that Mark is referring to is that in this particular case, like most, there was a rule of sequestration which said that if someone's on the stand, they can't go talk to other people. And if someone might be called back to the stand, if they're still under subpoena, then they aren't allowed to discuss their testimony or go out and learn about the case. They have to wait and come back for their second phase of testimony. So I think that's what Mark is referring to. And we did see some of those issues in this case. April Osteen, why are there only 6 in this jury? What in Florida law dictates how many jurors there are? Not a Florida lawyer, but some states have different standards on whether there would be 6 or 12. My state still has 12-person juries, but there are some states that have 6-person juries. Typically, not as much on the criminal side. There would be more on the civil side. It can be hard to pull together 12 solid jurors. That can. I'm back. Can you see me? I'm going off my phone now. We've got bad weather here in the area, and we got a message sent. They send them out sometimes. I don't know who sends these out, saying that there may be a big storm and warning in your area. But at the time, it looked totally nice outside. I found it hard to believe. And so anyway, I'm going off my phone. Hopefully the speed will be good enough. And anyway, we will resume with our questions and talking about that. But the internet is spotty here. So I'm just off my phone. I'm hooked off that. Hopefully I will go back to where we were talking about I was answering some of your questions. We were talking about the trial. One question I have, how many of you have been able to watch some or all of the trial? If you have, put a 1 in the chat. I'm curious. And if you haven't, put in a 2. And I'm curious, are you more getting full information here from me, or are you combining this with also watching? Just very curious. Okay, I'm going to go back up a ways. I don't know if I haven't answered your question, go ahead and put it in toward the end again, and maybe I'll be able to get to it. So Rita asking me, how was she able to go to her room and grab her loaded gun if he blocked her and was coming at her? So I think the way she described it was, she's retreating from him. He's coming at her. She goes into this room and he is at the door coming at her, and she shoots him from inside the room and he's at the door. That's how I understood the discussion. Indeed. Connie Presley, do you think she just wanted a kid and was jealous of his daughter, and she wanted her husband to choose her over his daughter? There was some suggestion about her relationship with Doug Benefield's daughter, who was 15 at the time. I never got the sense that she was jealous of the daughter. I do think the daughter had a real problem with the dad having brought home this new woman only 9 months after Eva's mother, his ex-wife, or his now deceased wife, had died. And without telling her, he had remarried. So I can understand the stress. Jealousy, I don't know, but difficult relationship, yes. Difficult relationship, yes. All right, so I'm taking a look for I forgot to say this. Be sure to put question marks at the beginning. That'll help me spot it. Kimberly, Ashley said Doug kept coming toward her after being shot. How would that be possible with a bullet in the leg or a bullet to the chest, since it paralyzed him? And that was one of the arguments that the prosecution made today during closing, was that the testimony was that as soon as the one shot through the chest happened and he was immediately paralyzed, his legs would have gone out from under him and he would have fallen. And maybe, but I gather maybe what she was doing was he's falling and she's still shooting. So maybe that's somehow, it seemed like the leg wound didn't make a lot of sense. And so the prosecution was suggesting maybe she did it while he was on the ground. At least that's how I understood what she was saying today. Kay Barone, the trajectory of the bullet was horizontal. So how does that confirm he was shot from the front? That is an argument the prosecution made today, and they used some really good visuals with that to show the direction of the shot, arguing that it was more side to side than front to back. And so it didn't look like he was coming at her. Since they don't know the exact order of the bullets, I suppose that people could argue, well, maybe she first had the one that grazed his arm and that turned him, and that's how he ended up getting shot side to side. All right, so someone asking, what are the questions? Maybe meaning the jury questions. I'm not sure what that means. So maybe give me a little bit more information and I may be able to answer that. All right, looking for question marks. Hopefully it's not frozen. Is it frozen? Okay. Where in the world is Lee? She is not, hopefully. I think we're still in. Where is she during the wait? Oh, where is Ashley during the wait? Probably she's right there in or near the courtroom. Maybe not sitting in the courtroom, but waiting near there. The judge asked everybody to be on a 10-minute call, which wouldn't allow you to go anywhere more than the far corner of the building. You couldn't even really leave the building or go get something at a store nearby. Jean Hanner asked, didn't they check the scene to see where he was when he got shot? Darn, I'm going to have to look at the whole trial. So they did talk about where the bullets were found and they checked the scene, but there wasn't a really thorough examination of the trajectory of the bullets other than by the defense. They had a defense witness, Michael Haig, who did a pretty detailed view of that, had kind of a cool exhibit and showed that was a video and showed in a 3D animation sort of way the direction of things that might have and how it might have all happened. Okay, so looking for question marks at the beginning. Does Jean wants to know, do I think there could be a hung jury? Always possible, always possible. And one thing we know for sure is that there must be some division among the jury because they actually reached the question. And we'll go back and talk about that now. Let's talk about what the jury question was that came out because it was very interesting and pretty telling. They asked about Dr. Quintel's testimony when he was brought back. The prosecution brought him and then the defense brought him back and said, was his description with Doug meaning the decedent, based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine. So somebody in that jury room was saying, look, this doctor supports the view that Doug Benefield was domineering, super controlling, alpha male, over the top, not genuine. Somebody supports that. And then somebody was saying, look, yeah, the doctor said that, but he got that from Ashley because he met with Ashley far more than he met with Doug, and she whined and complained about Doug. So all of that information came from her. It wasn't real. It wasn't an actual description of Doug. So we know that there is a split of views, at least about that issue. And so that's something, yeah, I think it could be, definitely, it could be a hung jury. It's possible. I think if they're very seriously hung, though, that they'll break pretty soon because they're going to need to come apart and then come back in and see if they can possibly reach an agreement on that. Okay, so all right, I'm seeing some 1s and 2s. So some of you got to watch, some of you didn't. I was interested in what the answer was on that. Okay. How long were they married? I think by the time it was all over, what would that have been? Something like the daughter was 2 and she was pregnant, I think, like a year afterwards. So maybe 3 years when he was killed. I don't know exactly. That's a good question, or an interesting question for sure. Kirsten Shipman, where does she stay when waiting for the verdict? I'm guessing just very near there. There may be a little room they've given her with her attorneys where she can sit. The judge sometimes has little rooms where lawyers can meet, and they may have provided that for them. Certainly, you saw her go out the front of the door. She didn't go back into the back area where the judge's chambers usually are. So she may just be somewhere in the courthouse. I don't know. Aslan Ahmet says she had the gun when he launched at her. If she had a gun before he launched at her, then Doug was the person in danger, not Ashley. That is what the prosecution argued today. They argued that she had the gun and he was in danger. She was the only person armed. He wasn't armed. Now, the defense, of course, has a very different story, and they specifically say she tried to escape the home, and he grabbed her by the wrist, swung her around, prevented her from leaving her own home, even though she had asked him to leave, and she was willing to get out just to get away from him, but he wouldn't allow it. Okay, so I'm looking for question marks at the beginning, and I've skipped all over, so please put your questions again at the bottom. Do you think the jury question is leaning toward the prosecution? Actually, Ashley asked me. I don't think it's possible to tell. I think the one thing we can tell from that is that there's a split in terms of their view of this. It could be one person versus 11, and 11 said, oh no, he said this. And the one person, well, wait, I don't remember it that way. That could be all it was. And so one person against the 11, they all feel one way or the other. But we do know that people had feelings on both sides, that they were leaning or thinking about both sides of the question. That's all we can really tell. We can't really tell which side was the one. Okay, so one of the reasons we're continuing the live stream and continuing to talk is that the jury is still out for the night. And what we're wondering is, will they break or will they come back with a verdict tonight? And if so, I'd love to be on live with y'all and we can talk about the verdict that they come back with. I'll go over the verdict form one more time in just a second so y'all can understand what exactly we expect to hear when they do come back. Okay, I am looking for question marks and I've been all over the place. So I'm going to head down toward the bottom again. Okay, looking for question marks at the beginning. That'll help me. And here's Kay Barone saying, didn't the prosecution show she had another way to exit the home instead of going to the bedroom? Well, the defense says she did try that. She tried going out, I think it was the front door, but certainly a door, and he pulled her back in. So, and one of the reasons they were so concerned about the burglary that we were talking about just a minute ago and about the request that he leave her home, she doesn't have a duty to leave her home. And she's allowed to defend it, any part of it. She doesn't have a duty to leave by any exit, as you might in some situations. It's her home. And so if someone's there uninvited and coming at her, she's allowed to take action. That's what the defense is arguing. And we'll go over their argument tomorrow at 7 p.m. Eastern so you can understand more about their entire argument and what was said in closing. He did a fantastic job. I really did feel like he did a great job. I also thought the prosecution closing was great. I thought they were both well done. Michelle Selby, do you think her new boyfriend should have taken the stand? Yeah, I wondered about that. Does she still have that boyfriend? I looked it up. I couldn't really find that. She had what looked like an engagement ring to some people. And Doug Benefield apparently thought, well, we better get divorced. I'm now filing since you're engaged to some other man, not obviously going to reconcile with me, as you've been saying. And yet, there they were, leaving for Maryland, packing together to move, which would certainly suggest she's no longer with the boyfriend and she is reconciling with Doug Benefield. That was when he got shot, was while he was helping her move all of her things outside of her home. So as far as whether the new boyfriend should have taken the stand, I can't see whether there would have been any reason for the defense to have put this person up. The prosecution probably didn't. If there is still a boyfriend, he just must not have had any information that was relevant. But we don't know a lot about him, so it's hard to really answer that question. Liz M wants to know what sign was her daughter holding in front of court. I think it was something about, free my mommy, or I need my mommy, something like that. And one of the controversies in the case has been related to a group that has supported Ashley on social media, and they have a website as well. We Stand with Ashley, I think it's called. And this We Stand with Ashley group has protested to outside the courthouse. They believe that she's innocent. One of the people who's protested, either with or without the group, was the daughter, who has held a sign outside. There's been some controversy over whether that was unfair to the child and something inappropriate to ask the child to do. In my view, it's, that's really up to the family, because certainly it would hugely impact the daughter if her mother is put in jail for 25 years to life. That's a pretty huge impact. So I can sort of understand I would leave that decision to them. I'm going to put it that way. My decision would be that I wouldn't want the child doing that, but I would leave that decision to them because I think it's not clear. What did you think about DNA issue? Eileen Santu asked. I thought it was a big loss for the defense. One of the problems that the defense wanted to solve was apparently DNA testing was done on Ashley's hands and wrists, and Doug Benefield's DNA likely was found on her wrist. It was likely to be Ashley, and 720,000 times more likely to be Doug Benefield and two unknown people. And it would be likely to be him, but it wasn't clearly 100% his DNA or something along those lines. But the defense didn't really have the witnesses to put it together. They didn't have the chain of custody, which the prosecution wanted them to lay. The judge seemed to want that as well. I didn't think they necessarily had to, but they also didn't have an expert to explain what the DNA evidence meant. And that was where I think they lost the ability to use that DNA evidence, and probably it won't even be a valid appellate issue because they just didn't have the witnesses lined up. If it had only been chain of custody, probably would have been a good appellate issue, at least an argument. So I do think that was a loss for them. Oh, thank you, Angelique. She likes the unbiased coverage. I appreciate that. Thank you. All right, looking for question marks at the beginning, and I know that I messed this up, so I may be going in the wrong direction entirely looking for these. Oh. Sky Goddess is glad to have me back. I'm glad to be back too, in more ways than one, now that we've lost the connection at least once, but I'm glad we're back. All right. Let's see. I'm looking for question marks. I'm going to go straight to the bottom and start over. It's a jury in Florida of 6, not 12, unless it's death penalty. She's saying, Michelle Selby, what about her boyfriend? Do you think he might have been a witness about her personality? You usually can't just straight go to somebody's personality. That's not relevant. The question of her personality, just in general, isn't going to be relevant. Character evidence is relevant under certain very limited circumstances, but you can't just have somebody get up and say, it's a great person. Because if they did that, if they allowed that, you would just have streams of people on either side saying, great person, terrible person, great person, terrible person. So there are places where character evidence comes in, but it's not just in general. All right. Looking for question marks. Juju saying what was supposed to happen on the 30th. That is in controversy, in fact. Moreover, what was the report that was supposed to be released? So, okay, there is a controversy over what was supposed to happen on Juju on the 30th. So you probably saw everything, and the controversy came out really in closing arguments. At the beginning, and what we had heard in advance of trial, was that on the 30th, a report was supposed to come out from Dr. Broder, who had interviewed and looked at both of them. And somehow this was going to be very negative to Ashley Benefield, sort of shades of the Michelle Troconis case and what was supposed to come out about Fotis's ex-wife, or she was still his wife at the time, his estranged wife. So that was what was supposed to be happening, according to the defense. And a lawyer for Doug Benefield got on the stand and said, yeah, that was what was going to happen. This report was going to come out. It was going to be terrible for her, or at least the insinuation was there that it was going to be bad for her. And that's why she killed him, to prevent this report from coming out. If that report came out, the state seemed to be implying then she would lose custody of her child. She couldn't afford that. She wanted the child and full custody, much less lose it entirely. So she had to stop that report from coming out. But that didn't really hold up during trial. The defense brought in very effective testimony about the fact that there was no hearing where Dr. Broder's report was going to be released on the 30th. There were several emails from the clerk that said it's not going to happen, the judge's clerk, and it just wasn't going to happen. In addition to that, Dr. Broder's testimony didn't suggest that there was some enormous issue he was about to release, some negative thinking he had about Ashley Benefield. So what was that all about? In closing, the prosecution shifted the argument, which really brought out the ire of the defense. We will hear that tomorrow night when we go over their closing argument. But the defense said, that's a brand new argument. And here's what it was. The prosecution said, okay, what was going to happen on the 30th was she was going to go ahead and push for the injunction she had filed for. Once she did that, it was all going to be over, because she had told Doug Benefield, we're about to get back together. We're going to be together. It's going to be the two of us going forward with our kid. And they dropped or at least they agreed at mediation, they were going to drop their various charges, his complaint for divorce, her complaint for an injunction. They were going to drop that, and they were going to move together to Maryland, where they would live separately, but where they would work on their marriage. And that was all going to be put to the lie. When they had the 30th hearing, it was going to be clear Ashley was going to push forward for the injunction. And when she pushed forward for the injunction, it was now going to be clear to Doug she wasn't getting back together with him. This was all just a ruse. She was doing this to sort of cut his feet out from under him. And the defense said, well, where did this come from? And he said to the jury, remember what they said in opening, and it's not the same as what they said in closing. They said it was one thing, and now they're saying it's entirely something different. So, Juju, you can be entirely forgiven for not being clear on what was on the 30th, because no one was, even the prosecution. So I'm looking for, how late do juries stay? Well, that really does depend on the jury, but it also can depend on some other things. I don't know if you remember the Bill Cosby trial. The judge said, okay, jury, you can stay late. And no, judge, they can't, because we only have X number of dollars to pay the bailiffs. And so all the bailiffs have to go home at 5, and we can't pay them overtime to stay late with the jury. And Just like, oh, okay, well, we're all going home at 5. And so it's really dependent. It could be really late, or it could be that they come back shortly and say, we made the effort, we've justified the pizza we had, and now we're going home and we'll be back tomorrow. Floa Ski, if he hadn't slammed open the bedroom door and blocked her in, do you think she would have shot him? And I think that only she can answer that question now, since he's no longer there. And I have no idea. The prosecution sort of suggests this was the plan all along. Where it happened, maybe there were some details that would be worked out on that, but they had the plan. The intent and the plan was, her intent and plan, I'm going to kill him because I'm not able to get what I want through court and through law enforcement. And if I can't get sole custody doing normal things, well, I am going to do what I need to do. And she even said pretty much that phrase to one of the doctors who testified. Now, he didn't think it was a threat, but certainly the prosecution took it that way. Okay. Erica, such a good question. Erica 528 Elk asked, was Doug trying to get sole custody of the child he had with Ashley Benefield? And that was, in fact, the prosecution said that in closing, and we had heard that before. And I mean, not before at the trial. I mean, that was something that was talked about before, was that Doug was trying to get sole custody. But that didn't come out or into evidence at trial. So the prosecution said that, and the defense stood up and said, whoa, during closing, said, you didn't hear that anywhere in the trial. There's no evidence about that. That didn't come in. So you can't consider that, jury, because there's no evidence about that. Now, what was interesting about that was he was very careful in the way he phrased it. He didn't say, that's not true. Doug Benefield, never was trying to get that. Instead, he said, there's no evidence about that. The reason he would be arguing that is the state would want to do it to say, this gave Ashley Benefield motive to kill Doug. If Doug was trying to get sole custody, she'd be furious about that. It would make him look bad, but also it would give her a motive. So the state wanted that, but the defense says, well, that there's no evidence of that. No one testified to that. So and he called them out on that, I thought, effectively. Rebecca, if Ashley is found guilty of second-degree murder, do you think she'll be sentenced immediately, given the judge already said it's a minimum 25-year sentence? I don't know. It is so dependent on what exactly this court does and what this state does. We saw a very quick sentence for Charlie Adelson, so I wouldn't be surprised to see it fast. But then on the other hand, you look at Lori Vallow, and months later, there was the sentence. So I don't know. We will have to wait and see. And, Lori Vallow got life in prison. It was a fairly standard problem. It was a fairly standard sentence for her, and that's what she got. But also, thank you, Rebecca. I'm glad that you really like the channel. I appreciate that. Angelique asked me, was the custody contentious? That is a really hard question to answer, Angelique, because it's hard to even argue whether they were having a custody battle, because at times they were and at times they weren't. And supposedly they were going to withdraw all of the issues that they had, all of the various motions, all of the actions they had filed there in Florida. Then they agreed to that at mediation, and they were going to move together to Maryland, live separately, but move together and work on everything. So in that case, there wouldn't have really been a contentious custody. It wasn't even clear there would be a custody battle. So that's a hard question to answer, but a good one. All right, misdemeanor. If you ignore what Ashley Benefield said and focus on what she did, she's guilty. She didn't fear being with him alone. And so that's misdemeanor's opinion. And I understand what you're saying. I think we're going to find people in our group who are on both sides of this, who really have significant opinions on both sides. Jean Hammer believes that having the young daughter outside holding the sign would be inappropriate. I can say what I would pick. I'm not gonna get into what the family should have done, but I can say what I would pick. And I would pick no. for anyone, any of my kids. I would just decide that's not what I want them doing. I wouldn't want them to feel responsible, to feel like they had anything to do with that. I would want them to feel like, what I did or what happens to me is separate. You're just a kid. You're not responsible for that. You don't have to come down and try to help me or worry that you didn't do it well enough. That's not that's not how our family works. That's what I would want. Liz M., curious if research shows if 6-member juries render more defense or prosecution verdicts. Oh, what an interesting question. I don't know. I'm really curious now, Liz. I would love to know the answer to that. And Liz is saying she would probably want 12 jurors. I agree for the defendant. Here's what I would think is that you're much more likely to get a hung jury with 12 people than with 6. There, you just got more people to disagree, and you've got a better likelihood. It only takes one person to hang the jury. So I would think that you would want 12 as a defendant. Okay. I think, no, I already answered Juju's question, so I'm going to keep going downward. So now you know where I am, and I'm going downward. So if you have a question, put your question in down below that. What about the impact to Eva, losing 2 parents and the trauma of this entire event? I honestly can't imagine. And bless her heart, she has sat through this, and it is honestly just hard to even imagine. Eva is Doug Benefield's daughter. She was 15 when he married Ashley. It was just 9 months after her own mother had died. So the whole thing is just brutal for her. And I'm looking for question marks at the beginning of the question. Connie wants to know, do you think they will have a verdict tonight? Well, I think it's possible. That's why we're hanging on here in the live stream. You know that I normally keep my live streams to about an hour, but I'm hanging on because I think it's very possible that they will have a verdict tonight. The reason I think that is they ordered pizza, they stayed in, and they're still going. That was a good couple of hours ago that they ordered pizza, and it's now 8:45. I don't know what time they would have gotten it, but anyway, it's still possible, I think, that they'll come up with a verdict tonight, and I don't want to miss it if they do. So we're hanging on. So questions, please. Gene Hammer is agreeing. I love your comments. Oh, thank you. You're impartial, and I appreciate it a lot. Thank you. I really appreciate that. Means a lot to me that you say that. That's my goal. My goal with the channel has been to take the cases that we're all kind of talking about that are so big in the media and just to make them understandable. I love reading about these, talking about them, and it's really fun to come on and talk to y'all about them and talk with you about them. We've had a lot of fun with that. Terry, who knows how late the jury will stay? I don't know. Oh, Loretta wants to know about the close-up of the artwork. Yeah, you betcha. You betcha. This Marlon, one of our moderators, our other moderator is Mama Pinks, but Marlon I'm trying to keep the glare off it. I've got a lot of lights around here, but that is the artwork that Marlon did. Maybe if I bring it a little closer. Isn't that amazing? I just love that. I think it's just absolutely remarkable, just crazy. And he put all these, he calls them Easter eggs in there, like things that represent somebody in my family or whatever. Anyway, it was just, I love it. So anyway, thank you again, Marlon. I love it. And by the way, Mama Pinks is one heck of a crocheter. So she made me a scarf that's just, wow. Okay, so, thank you, Janet. I appreciate it. I'm glad you like the analysis. I love doing these cases. I've really had a lot of fun doing this. It's been fantastic, so I appreciate it. ST Winter, thank you for the super sticker. I appreciate that very much. And Rue, off topic, what is the history of the beautiful swan on your lower shelf? It was in my very first solo office where I opened my own firm, and I had I had to go out and buy furniture and create a law office. And I bought that swan, and just to be on a bookshelf a lot like this. It wasn't this exact one, and I loved it. So actually, maybe it was this exact bookshelf. I take that back. It was this exact bookshelf. So it was bought for this bookshelf. So thank you. Thank you for that question. I appreciate that. All right. Where was her boyfriend? She could have called her boyfriend for help. Why Doug? It was obviously a setup, says Aslan. Well, Aslan, one of the things I would think is if she had this boyfriend who lived there in Florida and they were engaged, why was she moving to Maryland? So, what would she call him to help with? And that room that she was in had only, as one of the prosecutors pointed out, I think in rebuttal, it had a mattress, it had this laundry basket with the gun on top, and then a lamp or some one other item in there, I think, but it was basically empty. And the bed, the not bed, mattress was up and against one of the walls. So in that case, it looked like they were in the middle of moving. It looked like exactly what was happening, which was they were loading her stuff into a van. That's a long way to go to create the idea that you're going to move. And the defense maybe could have argued that a little bit. It didn't really look like, I mean, if you were going to shoot somebody, would you really go to all the trouble of moving all of your stuff just in case? I mean, that just to make it look like you were really in the middle of something and just happened to get into a fight. I don't know. That is a lot of trouble. So maybe I hate moving. So maybe that's why I feel that way. The Mixie Pixie asked me, can ineffective counsel be claimed based on failure to do what was needed to get the DNA in? I hate even talking about that because this defense lawyer has done, I think, a really good job. I think he did a great job. And it's the only thing. But I do think it was a shame. I don't understand how those pieces weren't laid. And it may be that he really felt like that the DNA evidence would be brought in by the state and therefore was taken a little off guard when it wasn't. So maybe that's why. Any kind of problem can ultimately become the basis for an ineffective assistance of counsel claim on appeal. So sure, could it be a claim? Yeah, absolutely. Could happen. In general, I don't think, I think he's done a good job. I mean, I really do feel like his closing was great. I think he did a great job. I have no negative comments to say about him at all. Vicky, if she's found guilty, what do you think it should be, second degree or manslaughter, and why? So, Vicky, I'm holding off saying anything I feel about the case. Jury's still out, so I'm going to wait on that. But I'd love to hear your opinion, so feel free to go ahead and tell me. All right. Universe Room said, has the defendant passed any lie detector test? And greetings from Spain. How great to have you join us. I don't think that a lie detector test was administered. In general, those are not admissible in courtrooms. So it probably wouldn't have come in even if she had. For that reason, it rarely could ever conceivably help the defendant. If the person passes the lie detector test, typically law enforcement says, yeah, it's just a lie detector test. And if the person fails, so see, he's guilty. So most lawyers will tell their client, do not, under any circumstances, take the lie detector test. There's nothing positive in it for you. All right. Still looking for question marks. Do you think the defense should have tried to get one or two of Renee's relatives to state what Doug was truly like? Kay Barone asked. It would have just been hearsay. It would have been, she said this to me and she's not here. And I don't think that it would have been admissible. They allowed in a text message that supposedly, I assume they knew this for sure, came from Renee, that Ashley found in the house when she moved in with Doug Benefield after they married. And this text message was, honestly, it was a little bit odd because it was so perfect. It was exactly everything why you kicked me on our wedding night was one of the things. And you kicked me hard on our wedding night. And you were this and you were that, and just kind of chronicled all the things he had done wrong. I thought, is this for real? But I guess it was. No one objected. So it came in. Rita Eichler asking how and when did she, and by the way, let me go back to that question too, Kay Barone had, because the question relates to the idea that If this was isolated, only Ashley complained about Doug, and there were a lot of suspicious circumstances around it. Well, maybe she made this up. Maybe the state's right. But if he was a serial abuser, if this had happened before, if this had happened with his ex-wife, or sorry, deceased wife, if it had happened before, it's not just Ashley. That goes to support Ashley's argument that he really was a person who might attack her. Maybe she was reasonable in her fear. Remember, the prosecutor said reasonable is one of the key words for you to look at. Reasonable, reasonably. Rita, how and when did she get the gun from her room if he was a threat to her? Well, she backed in, according to what we understand, she ran into the room, backed into the room. She's in the room and he's at the door. So she's trying to get away from him. She comes into the room where she has two guns. She grabs the one loaded, sitting on top of the laundry basket, and, gets it and shoots him. Kirsten is asking me, found guilty, will they take her immediately into custody? I wondered about that too. I was thinking about that because, like they go out for lunch, and I thought, is she thinking to herself, will this be my last lunch out for 25 years to life? Or what's she thinking? Is the daughter there to give her a hug? I mean, it's really unimaginable what it must be like, how much pressure there would have to be. Toy Thomas, what about the investigators not testifying because they have Proctor detective issues? So there was an investigator who did not testify. The lead detective, in fact, a lot like Proctor. So the lead detective was not brought by the prosecution. The defense brought him, and twice got in over objection and sustained by the judge that the prosecution hadn't brought their lead detective. What the heck was going on? Why not? Why did the defense have to do that? But the only thing that came out about what this lead detective had done was he had made a couple of statements in the probable cause affidavit when he was getting an arrest warrant for Ashley that turned out to be not true. Like, for example, the direction of the bullet, he didn't have that right. So there were some things that he said that really didn't work out to be accurate. And they say, so the defense says, well, maybe because he was so impeachable, because he had put these things in the warrant or the affidavit he had filled out, and therefore they didn't want to bring him because they knew he would be impeached. It wasn't the level that we saw with Proctor. It wasn't specific comments about Ashley Benefield like that. So I think that it was of a different nature. I'll put it that way. Okay, looking for the question marks at the beginning because that's how I can spot the questions. Oop, I think I just missed one. Aslan asked me, when the DA showed crime scene photos during closing argument, she has shown no emotion at all. She has sort of that impassive look at all times. The one exception to that, I can show y'all some, I snapped a few pictures of her. Let's see if I can pull that over. I got some pictures of her during closing, and they had just talked about how she didn't have tears and stuff. So I wasn't sure exactly. Let me pull this up and then do a share screen. And honestly, what you're about to see is, this is about all the emotion I saw, and it isn't a whole lot. Oh, it says the browser can't access my screen. Well, anyway, I can't show that to you. So I don't know what the deal is on that. It may be because I'm accessing through my phone instead of through the Wi-Fi, because we still have power, but it was blinking because of the storm, I think. All right, looking for question marks. There's movement in the courtroom. No, I've got it up over here on my phone. I'm not seeing that. I'm not seeing that anywhere. I'm watching that too. I'd like to know if they go ahead and break or if they come back with a verdict. That would be huge. All right, looking for question marks. And Kel Dell, what did the video show about Emerson's behavior after being in Doug's care? I don't think we we have any information about that came in at trial. So there may be some information out there like that, but it wasn't something that I saw at trial. There was talk about her allegations against Doug Benefield related to DV of the child, but we were told that never went anywhere, that law enforcement dismissed those, found no grounds for them, and never pursued them. So as far as I know, that's the truth. There may be a lot more to it than that. I can't really answer that. Oh, thank you. Aslan saying, I appreciate you reading questions and opinions in the chat. Thank you, Aslan. I appreciate that. Yeah, I enjoy this. I mean, I really enjoy talking to y'all and getting your opinions and your thoughts and your questions. It's a lot of fun for me. So thank you all for watching. All right, looking for those question marks. Aslan saying Aslan feeling it's a tough case for the jury, and kind of inclined to go with the jury will go for the lesser charge. Maybe the case. Juju, with a parenting plan without a divorce, are you allowed to take the child out of state? I think it all depends on what the agreement is, what the court has done, what the people agree to, and the state you're in. So can't answer that, I think, in the general terms. So as far as the two of them, they were going to dismiss every case and charge they had. Their charge isn't the right word, but everything they had pending there in Florida, and move to Maryland. The prosecutor hinted, why move to Maryland? She asked. And the insinuation, the hint behind that was, well, maybe the reason to move to Maryland is because you think law enforcement, it's another shot. South Carolina gave you a mutual injunction, but that's all you could get out of them. And Florida just wouldn't do what you wanted them to do. So Ashley Benefield moved to Maryland, hoping, well, maybe they will do something about it. That's what the prosecutor implied without actually making that argument. Terry M., why wasn't the door locked? I don't think there would have been time really, because she went into the bedroom to get away from him, and then he's at the door. So I don't even know whether it did have a lock. Probably a bedroom door would, but I don't know. Okay, looking for those questions. Is it common to keep a gun in your bra even when lugging boxes for your house move? P asked. I thought she was prepared and sent the mother to the park. There wasn't an actual argument about that, but there was that was implied. Why did the mother just happen to leave and take the daughter to the park? I'm sure the family would say, well, it's really inconvenient to have a kid running around underfoot, a 2-year-old, when you're trying to move big pieces of furniture and get ready to pack up your house and head to Maryland. And so I don't think the gun that she used wasn't on her person. There was talk about how she at times carried that. And I think they talked about that even the first time they met or shortly after. But the gun she used was in the bedroom, apparently on top of a laundry basket, as I understood it, and loaded, which is, wow. So definitely a mistake. Marlon, I don't see any movement in the courtroom. I don't see it. But we will keep watching. Laurie Marie, anyone else reminded of how Katie Holmes had to plan in the shadows before leaving Tom Cruise for fear of retribution? So, and obviously I haven't researched that case. I can't get into that at all. But one of the things that the defense argued throughout, including from experts, was that what Ashley Benefield had to do was avoid confronting. She had to constantly try to appease and to make things appear normal in order to keep Doug under control, under check. And they argued about that, but I don't know anything. I mean, certainly I read all the articles. We all did probably on that, but that's all I know. Aslan wants to know, was there a strategy to assign 2 female attorneys to this case? There were dozens of follow-up questions they didn't ask. I don't know. I can certainly see some reasons behind that. Sometimes there are strategies in which particular attorney, if you've got more than one to choose from, who gets assigned. Sometimes there are strategy decisions that go into that, but I don't think they'll ever share that with us. That would be my guess. Mallory wants to know, was Eva able to testify about the parents' marriage if there had been violence in the home prior? I don't believe she testified about that. I, I don't think she talked about that. And I don't know whether it's because she was very young. I mean, she was 14 and below because her mom had been dead for 9 months and she was 15 at this time. So I don't know what testimony she had on that. Misdemeanor. Do you think it was smart for Ashley Benefield's attorney to charge second degree or not guilty? So this is what I'm thinking. Misdemeanor is that the state picked the charges, and the defense just has to respond to whatever it is that the state picks, and they picked second degree murder or manslaughter, and not guilty being the third one. So that I don't think that Ashley Benefield really had a say in that. She just had to go with what they said. Now, she did try to get out of the charges using the stand your ground law in Florida, but the court ruled that she couldn't. She could make those kinds of arguments that she had self-defense, but she wasn't entitled to just get rid of the whole case because she qualified under the stand your ground statute. Okay, looking for those question marks at the beginning. And Kay Barone asking, do you know if the defense tried to get one of Renee's relatives to testify as to Doug Benefield's character? I don't, but I don't think it would have been allowed in. I doubt that because I would guess that it wouldn't have been allowed. So they may not have even tried. Aslan saying the American criminal justice system needs a reform. In cases where there's no other eyewitness, the defense has to prove self-defense. You can't prove something that didn't happen. And the judge, it was interesting because the jury didn't receive the full instruction on the burden of proof. They received an instruction that was really to the benefit of the defendant and not quite entirely accurate. So this is how the judge explained the way the burden of proof would work. The burden of proof in general on the state. State has to prove beyond a reasonable doubt that Ashley Benefield is guilty of either second murder in the second degree or manslaughter. That's their job. Now, when it comes to her defense, her defense of self-defense, that's now her job to at least bring forward enough evidence to put it on the table. So she had, and I'm just trying to give you an overall view. So she has the burden by a preponderance of the evidence, not beyond a reasonable doubt, just a preponderance. So 51% out of 100. So 51%, she has to bring that much to the table that, yeah, it was self-defense. And then the court said it switches back to the state to prove it wasn't self-defense or that it was murder, would be a better way to put it, beyond a reasonable doubt. The way the jury charge, and they tried to use a new jury charge that was supposed to work for that, but it didn't really work because it didn't fit with that. It didn't really say that. It left out some stuff. So they decided we're not going to use the new jury charge. We're going to use the traditional, just it's the state's burden of proof. So they never mentioned this part where Ashley Benefield has to bring at least a preponderance of the evidence to show self-defense. And only then does it switch back to the state. So I hope that wasn't too technical, but I thought that was really interesting. Angie Lapine, we are glad to have you as a new member. Welcome, and we are so glad to have you here. We may have a verdict, Janet is saying. Well, that would be super interesting. I am hopeful about that. I can't really, I don't see any movement, but that doesn't mean anything. It could be that it's coming. So we are certainly hoping for that. I'm hoping I'll be able to show it. I'm a little worried, but we'll be able to talk about it. Okay. So I am looking for those question marks. I hope I haven't skipped anybody right there. I'm looking for the question marks at the beginning. And I just came across ST Winters again. Thank you. Your super chat. And Ruse, thank you. Shay asking, Does Eva have a relationship with Ashley's daughter? I thought that several times. You would have to assume no, right? I mean, I don't see how that would even be possible right now, but I really hope that can happen because they are sisters, for Pete's sake. But it seems like it would be very hard. And right now, my guess is no. All right, looking for those question marks at the beginning. And I'm also keeping my eye over here to see if I see any movement over there. All right, let's see. I'm looking for question marks. I need to keep talking. So, K. Barone, do you know if the defense tried to get one? Oh, we already talked about that. Any updates on the Karen Reed case? Cindy Griffin asks. Well, the only update I know about is that there were 2 more troopers who were not charged, that's way too strong, who were the subject of investigation. There you have it. So those new troopers were the bosses of Proctor. It was Tully and Buchanan, and they are both now under investigation within the state police department, as I understand it. So that, will they be found in any way guilty? They haven't been asked to leave right yet. They have not been placed on leave. So that's just something percolating. Could it affect Karen Reed's case? You bet it could, because if all 3 of them end up being kicked off the force and they've all been removed from the force without pay, or they're pending, anything like that, yeah, it can make a difference. Yes, it absolutely could. All right, so yes, Karen Reed case, that's the only update I'm aware of right now. Troy Thomas, in the moment, which is literally seconds, sometimes milliseconds, there's no time for 911. Yes. And maybe, but if you're talking about Ashley Benefield, she did run next door, according to the neighbors who were out walking, within 30 seconds. So that was pretty quick. Lady J, could Ashley have a case for ineffective assistance of counsel? Yeah, we talked about that. Okay. So let me head over here and, thank you, Matthew. Matthew gifted 20 Lawyer League memberships. Thank you so much. I really appreciate that. One of the great perks you get as a member is special emojis you can use during our chat and as you make comments on the channel. They were all designed by Marlon for our channel, and they're really fun. They're fantastic. I think we're going to be doing some merch with some of those soon because they are great. I really want the village that he did on a sweatshirt, so I think we'll do that. And Rue asked me about mediations that I do. How often do you have both parties in the same room with you? So in general, and a little off topic, but I'll throw it out anyway. In general, with them while we're waiting. So the mediations that I do, typically I start out the day with all parties in one room. Part of the reason for that is we do a little bit of an overview. I want everyone to meet everybody. I want them to know these are real people, and I want them all to know everybody's there and we're all going to work together. From that point, typically you split the parties up, and it's because there's a lot of animosity. We saw it today, even in the closing arguments. The defense lawyer called out the prosecutor by name a bunch during the closing argument. And lawyers tend to really get at each other. They get upset. It's entirely contentious. The whole proceeding is starting from when you file the case. One side files something and you file the opposite. And that's how, in our system, we believe the trier of fact can make the very best decision. If 2 sides come at it from opposite directions, we figure that's the best way for the jury or the trier of fact to be able to make a decision. So typically the mediator will split them apart later. So one of the things I do, and what Rue is referring to, is I do mediations now, and I help people settle their cases without having to go to trial. And so I have 30 plus years. I won't say how many. I have a lot of years of trial experience, and that's one of the things I put to work to try to help people avoid that, which I really enjoy. Okay, so thank you for the question, Rue. Rue is almost surely a lawyer with questions about those sorts of things too. Lori Wallace is crocheting as she watches and telling Mama Pinks that Mama Pinks is serious crocheter. I mean, we're not talking just light stuff. I was like, oh, I'm a crocheter. No, I'm not compared to that. But I think I only partially said thank you, Matthew, for the 20 lawyerly gift memberships. I really do appreciate that. And ABC is saying, based on the chat, I think the defense lawyer dropped the ball. He should have focused on emotional abuse and really teach the jury. I'm confused myself. But that's good, ABC. If you're confused and the chat is confused, that's a suggestion that maybe the jury will be. And in this case, confusion helps the defendant. And here's what I mean by that. It's all or nothing. All members of the jury have to decide guilty for her to be guilty. If any one juror holds out, if they can't reach a conclusion, that's in the defense benefit. So, but I think ABC is probably saying that the defense should have focused on this because it isn't coming across clearly. And maybe that may well be the case. So I did feel like they did a good job, though. And I felt like the defense lawyer did a really good job at trial. I know that I typically say that, but I really did. I thought he did a great job. Okay, so looking for those question marks at the beginning and looking for movement to see whether we get a jury verdict coming in. Longest live stream in the history of the channel. So you were there. You were present when it happened. Nona Malou asking, why do they release alternate jurors? I thought, Nona, yes, I thought the same thing. I was stunned. I mean, I normally think about the Karen Reed case. Who were like, okay, you and over here and you three, you're going to sit right there and carefully guarded and protected because you may need to be called in. And there are provisions, at least in most states, that if a juror has to drop out and you no longer have your 6 or 12, then someone else can come in, but they have to start over. They can't just pick up where they left off. Like, well, the 5 of us think this. What do you think? It's not like that. They're supposed to start their deliberations from the beginning with the new person now included. But I really heard the dismissal of those jurors as being a goodbye, see you later. And I guess they're just up a creek if one of the jurors has to leave or get sick or something happens overnight. I think there would be a problem. I don't know what they do. Cindy, do you think the supporters outside are taking an idea from Karen Reed? Maybe a little bit, but I don't think exactly, because I think they've been doing that for a long time. I even did one of the, I think the first video I did related to this case. I was talking about the fact that there is this group, We Stand with Ashley, because I think that the way social media is affecting trials, really super important. And a lot of defendants just really haven't seemed to sort of understand or get that. And here we have 2 examples of defendants who have, or at least who people around them have figured out that that's pretty important. They approached it in different ways, but both of them had groups who supported them behind the scenes. And I think that can be important. I think it's also very much a game changer. Sharon L., new member, welcome. We are really glad to have you. And thank you to Matt for gifting the lawyerly memberships. If you would like one, you will have to turn on your ability to receive a membership. And Mama Pinks, one of our mods, will put the explanation for how to do that in the chat, because Matthew gifted 20. So there are more people who can get those. Tess says documentation of DV is key. Certainly true. Certainly true. Denise wants to know, are you going to tell us your verdict now or after? You know, I always try to avoid that altogether because I know just how controversial it will be. Veronica, why do you think they didn't defense-wise? I don't know what you're asking me, Veronica, why they didn't what? Maybe give me a little more. And I may skip over your question, but I may well get to it. So please put it down at the bottom. Guilty, will we hear victim impact statement? Cat Love Dreaming Peach asks. You know, we heard nothing like that in Charlie Adelson's trial, and that was a Florida trial, so maybe not. And really, we didn't get a full explanation of what it was with Lori Vallow either. We just knew that there was one, that there was information filed, some of which was confidential and not released to the public. Okay, Juju, what do you think about all the attorneys testifying? I thought this was very unusual. There were 3 attorneys who testified, at least 2 attorneys and legal assistant who testified. That is so unusual. And I've told you how contentious it gets between lawyers. Well, they came in on opposite sides as witnesses, so they disagreed in their testimony too. Really, really unusual, and it was absolutely fascinating too. All right, so looking forward to Nona, third time. Why does the judge release alternate jurors before a verdict is reached? I agree with your question, and I really cannot understand that. I was very, very surprised. I don't know if that's custom or just what he does. I don't know. Christine Ryan, what has been presented by the defense that has helped Ashley's case the most to prove self-defense? That's a great question. I want to put that back to you, though, because I think I'd like to do a video on that, sort of what were the strong points on either side. Would you put in the chat, what do you think was the number one piece of evidence in favor of Ashley Benefield's claim of self-defense? What was the piece of evidence that you said, that really mattered to me? And opposite side, what was the piece of evidence that really persuaded you, if what you think is that she's guilty, what was the evidence that made you think that? If you would put that in, that would really help me as I do this other video. I may do a group post on that. I may do a post on my channel on that as well to get your ideas. LMA, I think I skipped. Nope, I got that one. Here's LMA1, aka Sue. If she's suffering from PTSD or on antidepressants, it can make you numb. I can't really speak to that, but I do want to throw out one other thing. One of the things the judge talked about today during the jury charge was the fact that there is an exception that's allowed related to DV that isn't allowed for some other things like PTSD. He talked about the differences in the way the statute breaks out a DV incident. That was really interesting. Oh, great. I'm so glad that people are turning on their ability to receive memberships. There's something you have to do. Sharon and Laurie Marie are new members. I'm so glad. Welcome, welcome. We will be having our next member event. I think it'll be next week. I have to look up the date on that, but I think it's next week. Yeah, I'm pretty sure that it'll be next week. So that'll be our next members only event. Will be coming up soon. And I'm so glad that you will be able to join us. So Cindy asked me, I already answered that. I'm looking for question marks at the beginning. Remember, that's my way to spot you in the middle of the chat. Cat girl, did she usually have her gun loaded and with her at all times, or did she just have it ready when he was around? She had it, from what I understood, on a laundry basket in a virtually empty room. They were moving, and it was sitting out fully loaded on this laundry basket. And she has a 2-year-old kid, which is terrifying, or did at the time. Maya asked, I can't answer that. Roseanne, her mom inherited a house in Maryland. Is that the reason for the move? Don't know. I wondered about that. Why on earth are they suddenly picking up and moving to Maryland? Where did that come from? She was in South Carolina when she met Doug Benefield, and then she moved to Florida to be with her mom. So I wondered, where did Maryland come from? Jasmine, if she's such a liar and master manipulator, why wouldn't she say he'd hit her before? And why wouldn't she make her injuries that day a little worse? Well, there's some questions that are really good questions. Now, one of the points made today in closing argument was, according to the neighbors who were walking by, they heard shots, and within 30 seconds, Ashley Benefield came tearing out the door, terrified, and ran to the neighbors. They saw all this. And the defense said, look, if she planned this, if this is a murder, she's been working on this for a while, wouldn't she take a little longer to look over the scene, make sure there's nothing she's forgotten, make sure she hasn't left anything out? Wouldn't she do that? Because that 30 seconds is awfully short to make sure you haven't left some incriminating piece of evidence or something at the scene. And the fact that she came out the door pell-mell in 30 seconds tells you this was a real traumatic event, not one that was planned, not one that she ever intended. So that was one of the arguments they made. I thought it was a really good argument. BRV wants to know whether I would recommend that the defendant ensure eye contact with the jury. She appeared to do that. It, it's such an awkward issue. You remember when Amber Heard testified, people criticized her because the lawyer would say, question, question, question. She would turn to the jury. I forgot which way it was. I guess this way. And she would, question, question, blah, 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 blah. Question, 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 blah, blah, blah. And so she every time literally turned and faced the jury and gave them what she had to say every time. And there was criticism like that. It was overkill because it was so deliberate each and every time. But I think she was probably a rule follower. And in general, lawyers tell their clients, look at the jury as you testify. The same would be true, of course, for a defendant sitting at the table. You don't want to appear cold. On the other hand, you don't want to overdo it. And you don't want to appear to be staring at the jury. You don't want them to feel uncomfortable, like you're staring them down and they start to think there's something sinister or wrong with you. So, that's just a hard question to answer. It's a balancing act where the person doesn't want to appear closed off and never contact the jury. On the other hand, they certainly don't want to be staring. They just want to look normal, relaxed sort of approach within the courtroom. We are, for those of you coming in, we are waiting till the jury has not left for the day, and we are wondering whether or not they will come back with a verdict. So we're just kind of hanging out as we're waiting. I'm answering questions. We're talking about the case and what's happened in the case so far. Lynn McComb, did Ashley Benefield refuse to talk to investigators the night of the shooting? I didn't hear any tapes from interviews. She seems to be very smart. That was something that was said today in closing as well. Someone said she's very, very smart. I think it was the rebuttal. Said she is a very smart person, and therefore she was trying to beat the system. She felt like she could, and she's pretty smart. So she definitely did. She did not talk openly. Certainly, we didn't, as you said, we didn't hear anything of police interviews. She also, according to her mother and someone, their relationship wasn't some kind of friend or something. She'd lived with her for 9 months. And they both testified that she had never talked to either of them. She had never revealed her opinions or what had happened. She never described it to them. And that was on the advice of counsel. And so she had to have very quickly gotten to an attorney because of the fact that she never told her own mother and she lived with her mother. So that would just sort of be something, if you hadn't talked to an attorney and been told don't talk about it, then probably she would have. Lynn McComb. Okay, so same question, sorry. And I know I did ask you to put your questions in again, so my bad if you put it in more than once. Not your bad. Okay, so I am looking for the question marks at the beginning. That's my best shot of finding you in the middle of the chat because there are a lot of comments and not all of them are questions. So I'm looking through for question marks at the beginning. We can't possibly be running out of questions. Angelique, did the boyfriend testify? No, I don't believe any boyfriend testified. And there are people who have asked about that. There was testimony about this ring that Ashley Benefield was wearing, and that when she took another man's ring, supposedly maybe an engagement ring was the implication, then that was when Doug Benefield said, whoa, we got to get divorced if you're going to marry someone else. Certainly a reasonable position, but we didn't hear anything more about that. And at the time of his death, she was supposedly moving to Maryland with him. He was going to go up there too. He was packing her belongings in the same truck with his. They were moving all of their things to Maryland, and they were going to be living there, not together, but they were going to co-parent their daughter there. All right. So, okay. ABC saying the reason I say the lawyer dropped the ball is because we think physical violence justifies death. Lawyers should have focused on how emotional abuse can lead to lethal action, especially when they lived apart for the 3-year period. And ABC is making the point that a key argument by the prosecution was, while Doug Benefield clearly did some things that were wrong and he did those things that were wrong early on in their relationship, it had been 3 years. Most of the time they've been living, well, they have been living apart for this period of time. They weren't together. They didn't share finances. They didn't he didn't have any control over her, practically speaking. And all of those things are ways that he was not controlling her for 3 solid years. So why is she still afraid of him? What would cause her to flash back to 3 years before if for 3 years he's done nothing? There's been no violence, nothing's happened. And I think, excuse me, ABC is saying that maybe the lawyer dropped the ball because there needed to be less emphasis on physical violence and more on emotional abuse and the way that leads up to actions, even after a period of time. And ABC, I think, I understand your point. I think the lawyer believed that the witness who showed that DV wheel, it talked about a variety of different ways that a DV abuser could actually control somebody, that it was all about power and control, and talked about all those different ways. And so I think that the defense lawyer believed that all of that incorporated and pulled in some of those ways that were emotional, not just physical. So that would be my best guess on that. So thank you for that comment. I appreciate that. And thank you for doing a super chat to ask the question. I appreciate that. Who is Renee? Renona asks, and I better take a drink of water. So Renee is the former deceased wife of Doug Benefield, who died 9 months before he met Ashley Benefield. Now, they met, and 13 days later, they married. There was a 30-year age gap, and they married within 13 days. So unusual initial meeting. Julie, interesting question. Asked, why did Ashley move in with the therapist? That was the friend that I mentioned. There was sort of a hint in rebuttal where the prosecutor said she had something going on with this person. We don't know what it was. I don't know what the implication of that was, because we got no testimony about that. But the implication made in that rebuttal closing argument was, well, maybe there was something that was going on and between them. But I don't know. I have no idea what was going on. The only testimony was that she lived there for 9 months. She lived with this woman for 9 months. So, and her family, this woman and her family, as I recall it. So I don't think it was anything. Well, I don't know. I just noted that in the closing. I thought that was really interesting. So ST Winter asking about the Trayvon Martin case, and I honestly don't know enough about that to comment. It's always interesting to pull some connections between the cases. I enjoy that too, but I don't know enough about that one to be able to do that. I didn't cover that. So, okay, looking for question marks. Don't forget to put them at the beginning. That's my best shot of spotting your question. Okay. Allie, thought it was odd that the real estate agent testified that Doug inquired about the property behind and said he'd have to check with Ashley, but no one confirmed whether he did tell her that. Well, that's interesting. That is true. No one asked that. But I think what the defense was relying on, the defense position was that Doug was basically kind of a stalker, and he came into this situation and he was skulking about her house in the middle of the night. That was the person identified by the voice, the neighbor identified by voice, and he tried to buy the property right behind her. But the way that sort of ended during the testimony was the real estate agent said, actually, I wrote Doug about this property. And when I did, he said he might rather rent. Maybe he wasn't really sure he was going to buy. And he also said he'd have to ask Ashley. They would need to talk about it. And therefore, I thought it ended up not being as strong as the defense probably wanted it to be. I mean, it sounded super creepy at first that, hey, I know we're estranged, but I'm going to buy the house right behind you. It sounded super creepy, but when the testimony sort of shook out, it seemed less so. That was my read of it anyway. Cat Girl, is her dad still in the picture? I'm not sure. Maybe you mean Ashley's dad. I don't know. We didn't hear anything about him. I have no idea. Good question. Interesting. Floa has. Now that's impossible. I get the impression that you don't believe Ashley. You could not possibly have that impression. I have so carefully said nothing at all. Well, although one of my great joys is I will get comments like, I think you are really pro defense. And in the same set of comments, you are too pro prosecution. My job here is done. Yes, indeed. I have managed to successfully go right down the middle when people think I'm on both sides. So hopefully that's the case here too. All right. So, Carrie, what did you think of the yelling prosecutors in closing? I didn't think they did too much yelling. I didn't feel like that was an issue. I felt like the rebuttal wasn't as effective. It was more general. I felt like, we do have movement in the courtroom on my phone anyway. Not on my computer. What would that be about? Why would that be, I wonder? Did y'all see that? Did anybody else see that? Now it's gone back to just the shield. But in any event, I am really curious whether I will be able to share the screen. I'm going to try this. Sorry, I need to keep talking. Y'all think, oh no, she's frozen again. She's dumped. So let's see what I've got here. Let's see how we do on that. Does it share? Yes, it does share. But I don't know yet whether we have sound. That's usually the issue. I'm going to remove that for now since there's nothing going on. But I am curious. So what I felt like about the rebuttal was that it was general, and there were a couple of things in there where I thought, that could really hack somebody on the jury off. I'm not sure that was really helpful. It took anything anywhere. I honestly felt like they'd said everything they had to say in the first hour, so I wasn't sure they really needed that. Typically, the prosecution, if they're allowed to do the opening and close of closing arguments, then they'll save some time back so they can respond to arguments by the defense. The reasoning behind letting that happen is the idea that I see movement again, but the reason behind that is that the prosecution bears the burden of proof. And so the idea is it's fair to let them have the final word. And that's often the way it happens. If the state changes their motive, does that affect or cause error in appellate issues? Asked Patty. In this particular case, I wouldn't think so, because that was more of an explanation of why she did something. Was her motive because the hearing on the 30th was going to relate to one issue versus it was going to relate to another issue? So I don't think that would be an appellate issue, but it made the defendant really mad. And but the defendant very rightly pointed that out. The defense lawyer said, hey, look, jury, they're changing this argument. That shows you that they don't really have a good handle on what her motive was, so don't believe them. I thought it was pretty effectively done. Okay, do I know minimum maximum sentences for second degree and manslaughter? Not for sure, Cat Love. What I looked up, it seemed like with the enhancement of it being a firearm, that 25 years was the minimum mandatory sentence, and it would be 25 years to life on murder second degree. Manslaughter, it looked like 15 would be the maximum, and it could be something under that. So, but I don't feel fully qualified to answer that. That's what it looked like when I looked it up. We will, if she's convicted, we will find that out. I'm also very curious what will happen. Would she be taken immediately into custody? And it's just going to depend on that. I think that happened with Charlie Adelson. So I'm guessing yes. How long can they go into the night deliberating? Well, I'm thinking not much longer. I'm thinking that this movement and people coming into the courtroom suggests that they've been given the 10-minute notice. The judge asked everybody to stay within 10 minutes of the courtroom so that they could come back in and talk about and be ready to hear from the jury if the jury came back. Okay. There's no sound on it yet. Let's see. So there's no sound on it, but as you can see, the judge is up there. Stand by for jury question. Oh, those are so interesting. I just love a jury question. That's what Law and Crime is saying, is to stand by for a jury question. But there's no sound yet on. It haven't been turned on. So, and I mean by Law and Crime, they haven't turned on. Whoever is doing the court, it may be Court TV. So we will, if they have another question, that means they're in heated debate and possibly going to still debating. It means they don't have an answer for us yet, if it's just a jury question. And the judge seems to be looking it up on the computer. I am super impressed with this judge. He is really bright and a seriously hard worker. Marlon, do you remember the switch to put on audio in PIP? Nope, I don't. I don't know what you're talking about. I do remember that I had to open it up a different way than I had opened it last time. So we are hoping that I managed to do that. We will find out. Hey, flipping out as a new member. So glad to have you. We are really glad to have you as a member. So everybody has come back into the courtroom and we are standing by for a jury question. So, and we will see if we have sound, but I'll be able to tell you what the question is in any event, because I also have my phone here. So we will, as soon as they turn the sound on, what they've done typically is they keep the sound off until I guess the court gives them the high sign. Go ahead and turn that on. And here is Ashley Benefield coming into the courtroom. And she will be assuming her seat. I seriously can only imagine how nerve-wracking this moment would be for a defendant. Can you hear that? Can you hear that? I think you can hear that.
Back, everyone. We're back on the record. State of Florida versus Ashley Benefield, 2020 CF 3014. I have another communication from the jury. I'm going to read it verbatim, and then I'll hear from both sides.
Okay, I'm going to write it down.
Unable to come to unanimous verdict. Signed, juror.
That's an easy one. It's been less than 6 hours. Keep working.
Yeah.
But with this caveat, Your Honor, I think you should at least acknowledge to them, because I don't know that either out of politeness or a sense of intimidation, I don't know that they know they can ask if they can go home and come back in the morning.
Judge, and I think asking them about going home, coming back is definitely something that they also need to Allen charge before we make any decisions after that.
I'd be given Allen charge after 6 hours.
Yeah, hold on. Just go ahead and say your piece.
Judge, I didn't realize that there was any hour attached to an Allen charge. I just thought that once they said they were deadlocked, that you give them the Allen charge. But it is almost 10 o'clock, so they may want to go home and come back tomorrow.
All right. Thank you both very much. As we all know, the Allen charge is a one-time thing. So my inclination was to bring them out, acknowledge that they've been working for almost 6 hours, well over 5.5 hours, acknowledge the time of the evening, and give them that option. And I'm not going to ask for them to vote. The way I do this is I'll explain to them, you've been working. We acknowledge that it's late. If you want, you can go home for the evening, come back tomorrow fresh, and continue your deliberations. I send them back to decide if that's what they want to do or not, and then go from there.
Yes, sir.
Okay?
Okay.
All right. Let's bring them out.
So we are in the spot we were in the Karen Reed case. And this goes to what we were just talking about, which is the potential for a hung jury. And the fact that their first question out of the gate, and it was a pretty quick one, suggested they had a divide among the jurors and they didn't agree. And that we now know is still the case. They wrote that they are unable to come to a unanimous verdict. And we know what happens because we just watched it in the Karen Reed case. The court will give there are different names for it, different places, an Allen charge or a dynamite charge, where the court would tell the jury, yeah, go back and try again. I know you think you're at a hard spot, but go back, really listen to everybody else, try to open your mind and see if you can reach a decision. But what's happening here is there's disagreement. The state is saying, just give the Allen charge. And the defense is like, you don't do that until they've tried a while. I mean, you don't do that after 6 hours because you're at serious risk of getting a hung jury. Nobody wants that here. Everybody would like to have it just handled. And the defense has done a good enough job. They pulled some jurors at least to their side, and that's their end goal. That's what they want. So the defense is looking at this as, hey, let's get a verdict from this jury. It's looking like it could be one of our best shots. And so that's what the defense is arguing. The defense is saying you don't give an Allen charge after 6 hours. They have to have tried a lot longer than that. But everybody is noting that it's really late at night. They've been going a long time, and this is a lot to ask for them to keep going.
Welcome back. Members of the jury, I've received a note from you. It says unable to come to unanimous verdict. We all recognize that you've been working for almost 6 full hours, and it's almost 10 o'clock in the evening. I want you to go back, and there's an option that we can come back tomorrow and start fresh in the morning. I do have some court first thing in the morning, but we can get started same as every other day about 9 o'clock. So I'm going to ask you to step in the back and make a decision amongst yourselves if you'd like to come back tomorrow morning fresh to start.
Or there's no other option.
I need you to discuss that first, please.
Remember that what are the other options? No, there are no other options, basically, or you keep going. So remember the Karen Reed judge said, clear your minds. Let's everybody go home, take a break. Let's see if we can come back and decide. Ultimately, she did have to declare it a hung jury and declare a mistrial because they couldn't all agree. Could it happen here? You bet. It absolutely could. And we know that the jurors don't agree based on what they've discussed so far. It's not really a surprise to me because this case, like the Karen Reed case, we see a lot of split in the comments. In a lot of cases, we see pretty heavy conclusion that one side or the other is right. And typically it's that the defendant is guilty, is what I'm normally seeing. Karen Reed case was different, and this case is different. We see a lot of different opinions and differing opinions in the chat and in the comments. So there are people who strongly believe that Ashley Benefield is guilty and should be convicted. And there are also people who strongly believe that Ashley Benefield is not guilty, that she is being prosecuted and all she did was try to defend herself against someone attacking her, that she was a victim of DV. So there are very definite splits in this case, just like in the Karen Reed case. So is it possible that the result will be a hung jury? It absolutely is possible, but it's way too early for that. And both sides are acknowledging that. The state is saying, give the Allen charge, and the defense is saying, too early for that. But ultimately, everyone agrees that's the road we're traveling down if the jury can't reach agreement, if they can't all decide on a particular verdict. So, but right now, the judge has given them the option of, would you like to go home for the night and come back tomorrow? It's 9:47 here on Eastern time, which is what they are. They're on Eastern time. And so it's late at night and time for everybody to go home. It was kind of a brutal afternoon because the judge did the jury instructions, which were about 20 minutes, then the prosecution opening, which was an hour, the defense closing. The defense closing, which was roughly another hour, and then 40 minutes in rebuttal for the state. So the bottom line was it was about 3 solid hours with no breaks and just solid talking. So it was a lot. It would have taken a lot of energy to focus on that and to pull in all the information that they were being told by all of those by the prosecutor, by the defense, by the judge. And then they had to go back and for the first time start talking about and arguing about this case. And so they don't agree. Will they change their minds tomorrow? Maybe not, but they have had quite the day. They arrived at 8:30 in the morning. They had a little bit, then they had some time off, but they have been solidly absorbed since 12:30 in the afternoon. So that is a really long day considering they'd already been there for about 3 hours. So it's been a full day for them. And if I were back there, a fly on the wall, I'd be like, take the break. Everyone needs it. And I just think that would make sense. And obviously, both the prosecution and the defense think the same, and the judge gave them the option. But it sounds like he's not going to make them leave. They can leave if they want to, but he's not requiring it. So, M. Meyer says, fun fact, the AC gets turned on as needed for energy conservation. Gets a wee soggy. Yes, it would. Boy, that could really be a way of sweating it out. That used to be sort of a joke for when associates were doing document reviews. They're going to turn off the AC and sweat it out, make them go to a warehouse somewhere, and they'll stop reviewing the documents. But certainly, hopefully that's not happening in the courthouse today. Or if it is, hopefully it's still working. Hopefully they filled out the authorization to keep the AC on. Kimberly asked me, can the judge ask the jurors, is there any charge they agree on, like in the Karen Reed jury? Here's why I don't think that'll be what happens here, Kimberly, is because the way the verdict form is phrased, they were told, here are your 3 options, pick one. So their options are murder in the second degree, manslaughter, and not guilty. So that's pretty clear. Now, there were some enhancement issues down there related to whether a firearm was used. In this case, that shouldn't be super controversial. We know that a firearm was used, but she admitted that a firearm was used. He was shot. I don't think anybody's truly arguing that or objecting to that. But, definitely they might need some instruction that if that's your only issue and can you answer A, B, or C? Maybe they would need the answer to that, but I think it's pretty likely they know what they're doing here because it was so clear. And the verdict form just wasn't as crystal clear in the way it was drawn up in the Karen Reed case. So I feel like there's some differences there that will make this jury have an easier time understanding it. It's just a much simpler way of doing it. The Karen Reed case had 3 different charges, and the jury didn't have to pick. The jury could find more than one or just one, and then there were lesser included under one charge. So it was just a more complex verdict form. This one, I think they'll be able to handle a little more easily. Susan Moore, so glad you stuck with us, Lee. Good. Well, I'm glad to have y'all stick with me too. Thank you for sticking with it. Eileen, I do not understand why jury instructions do not include instruction reg readbacks. I don't know what an instruction reg readback is. Maybe that's like explanations that come with it. The theory that lawyers have is they've been made super simple for the jury, but in practical terms, that is often not the case. So if that's what you're saying, Eileen, it can be a weakness. It can be something. And jury instructions are supposed to explain the verdict form and all that, but sometimes it can be very difficult for the jury to understand that. All right, so I'm looking for my questions. If she is found not guilty, Aslan asked, what will happen to Doug's property and assets? How does it work in the U.S.? For one thing, it's going to be governed state by state. But if she's found not guilty and they were still married, then I would assume his property and assets would pass. If he didn't have a will, then they would pass under the state where he was domiciled at the time. I'm guessing that was Florida, but it is a little unclear since I'm not sure if he ever actually rented a place in Florida or whether he was just commuting back and forth. Don't know the answer. But as far as his property, it probably would belong to her. I don't know how much he had. And a lot of times the estate law, which is state governed, would include the child, Eva, here in this case. We'll just find out. Okay.
All right. The response from the jury is we will stay. Signed by a juror.
What? 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 That's crazy.
So we'll be in recess until we get another question or a verdict.
Oh, wow. Wow. Okay. I got to know. Are you shocked? Give me, if you're a member, let's pull out that shocked emoji. Okay. If you're not a member, give me a 1 if you're shocked by this, and a 2 if you're like, nah, I figured it. That's what I thought was going to happen. I'm a total shocked emoji 1. I cannot believe they said they're going to keep going because they don't even know that there's still this Allen charge out there. The dynamite charge hasn't even been given, and they're going to be required to spend a number of hours more at that point. So, whew. All right. Well, I knocked me over with a feather. I am really surprised. I am surprised that maybe the judge will make them. If they come back in and say again, 1, there are a lot of 1s. Me too. I am stunned. I cannot believe that. 1s. Oh, there's a 2. All day 2. And Meyer was just sure of it. Well, I was not. I am gobsmacked for those of you from the UK. Okay, 1s, a lot of 1s. That's how I feel. I am really, really surprised. So I was curious, were you as surprised as I am? I did not think that would be what would happen. Well, okay, there's a couple more 2s. What else can we do? Stay all night? Eileen's view, and Jennifer felt the same way, but I'm a 1. I am really surprised. Child of God is thinking. Lot of 1s. Okay. Well, I guess we keep going. We're going to have a lot. You are going to have to participate. We're going to have questions here. I can only say so much off the top of my head. I'm going to count on questions from y'all. Let me see. I have to agree with you. ABC says these jurors get an A for determination and grit. They do. And for wanting to get out of there, you have to give them, that is impressive. That is impressive. I have to agree with you. And Shiraz, thank you for gifting 10 lawyerly memberships. We really appreciate that. Thank you so much. All right. So we are counting on class participation here. So we need to have questions and thoughts from you. So I'm going through looking for question marks at the beginning. That's my only shot of finding it in the midst of all this chat. So let's see. 1s. I'm a lot of 1s. I am totally with you. I thought sure they would say, let's come back in the morning. I 100% would have said that. They want the day off tomorrow. Dr. Kara says, yes, they must really, really not want to come back tomorrow. They just really, Rue, she's now free. I mean, can you imagine? Can you even imagine? It may all be coming to a head within an hour. Wow. For free hotel, I don't think they're sequestered. I don't think they're being sequestered. I think they would be going home. So sometimes the jury is sequestered. It's really pretty uncommon. I only ever had one jury that was sequestered, and they were put up in a hotel for, I think it started at closing and during deliberations. It ended up being several days. I can't remember. It's been a long time. But anyway, that was the only time up all night with Lawyer Lee. I hope not. I hope that is not the case. I hope we are going to get a quit decision, or even just that they would go ahead and decide to take the evening off. That would also be good. Crystal Dawn, new member, welcome. Super glad to have you. All right, Justice Scales. If most want to stay, is it that there might only be 1 to 2 holding out? Yes, that is what I'm thinking too, is that maybe the reason they want to stay is the majority is thinking this will help us put pressure on this minority that wants to do something different from what the rest of us do. In that case, I don't know. I don't know which way that runs. It all depends on which side they were on in that first question that the jury asked. We'll talk about that in just a second. We'll go over the questions again. We now have 2 from the jury, and every single question that comes out of the jury room is a clue. It tells you a little bit about what they're thinking. Even little things like, can we get a copier? Really? Well, what would you want that for? And so those sorts of things. Denise, tell us about your vacation. I'm going to stick to law, but it was really fun. I was with the grandbaby, so that was super fun. 2 under 2. Is there anything more wonderful than that? Although they don't sleep. It's the only big shock to me. I thought I would have an easier time doing live streams. And it was just round the clock, but it was a lot of fun. It was a lot of fun. Cat Love, can you talk about the judge's instruction for the jury to consider her demeanor on the stand? I think what you're talking about is that the judge says you can look at the way people answer questions, how they look. You can decide about whether you believe a witness, and that applies to every witness, including the defendant, since she took the stand. You're allowed to assess their credibility. You don't have to take what they say at face value. Oh, yeah, that must be true. You don't have to do that. What you could do is say, I don't believe that. I find that incredible. I don't accept that testimony. Or you can say, I do accept that testimony. And you can take parts of it and say, I believe this, and I don't believe that, and I believe this. You're allowed to do that. And you're also allowed to do that with the defendant's testimony, because she was a witness, just a regular witness like everybody else. And so you use the same standards that you would use with other witnesses. Nifty 50. Most likely they've decided to try one more time, but it might end up hung anyway. The information they don't have, you're right, Nifty 50. That might be what they're thinking. Well, we'll try again. And maybe the majority is thinking this will be the catalyst to go ahead and push that last group over. But what they don't know is the judge is probably not going to let them do that. He's going to give them the Allen charge, and he may not do it tonight. He may say, you're going to have to come back and get this charge and start over again tomorrow. Start over is a little strong, but you have to start again. You're going to have to try again. That'd be the best way to put it, tomorrow. So that may still be coming. Okay, lots of ones. I am so with you. Have you ever heard of a jury going overnight? Carmina asked. I have never heard of that. Has it happened? I'm sure some jury somewhere has, but I have never heard of that. I have never had that happen. The laughs way too loud says, do you think that means there's only one holdout? Either way, I think it means, I don't know for sure, but I kind of am tending to the idea that means there's a small group on one side and a big group on the other, whichever way that would be. Jay Ray, can you please go over the lesser included charges? So the lesser included charge was manslaughter. So murder in the second degree, manslaughter, not guilty. They were given 3 choices. Now there were some, let me pull up my notes on the jury verdict form. I don't have a picture of it, but there were also some issues that weren't charges, but that would relate to enhancements under Florida law. If these enhancements are found to be true, then the judge is required by Florida law to put a mandatory minimum sentence. So we, the jury, find as follows, and they have to check: 1, guilty of murder in the second degree, guilty of manslaughter, and that's a lesser included offense, or not guilty. And if they find A or B, guilty of murder in the second degree or guilty of manslaughter, then they have to answer these questions. Number one, did Ashley Benefield actually carry a firearm? Yes or no? Number two, did Ashley Benefield discharge a firearm? Yes or no? And number three, did Ashley Benefield, as a result of discharging the firearm, cause death to Douglas Benefield? Yes or no? In this case, I don't think those will be all that hard to answer. I think both sides would pretty much agree. Maybe whether she actually carried a firearm, that probably wouldn't be accurate. It was back in the room, but she did discharge a firearm. So with number two, I think they would check that. Number three, as a result of discharging it, it caused the death to Doug Benefield. So I think they would say, I think both sides would say yes to number two and number three, maybe not number one. Depending on, I don't remember how carry was defined, but depending on that, maybe they would answer one as yes or no, but it seems less suited than two and three. So those things are there because of this statute under Florida law that would enhance the verdict. Sorry, the sentence would enhance the sentence. It would be a mandatory minimum. And so that's what the court is trying to find out. It will use that then for sentencing. It won't, I mean, that's not really a concern of the jury. They're just supposed to answer those questions. So that's the verdict form that they will be looking at. Those are my notes of it. So hopefully I got that pretty close to correct. All right. Now, let's see. A, B, C, is there anything you would change in the defense closing? I thought the defense closing was great. I thought he did a great job. I really did. I felt strongly that he did a great job. The only reason that I rated the prosecution a little higher, and that's so arbitrary, but in their initial closing argument, was because I felt like the defense had been fairly clear throughout. And so he brought that and placed it from the jury clearly and cogently. And I felt like the prosecution had some work to do, kind of cleaning ends up, and she did a really good job doing that. So she had more to accomplish than he did, but both of them laid out for the jury pretty clear explanations of what their positions were. I thought it was refreshing, and I thought they did a really good job. Child of God, what is the deal with only 6 years in Florida? I think you mean jurors, right? That's my guess, what you're saying, 6 jurors. And it is unusual, although some states have gone to that. Some have that only in civil cases. Some have that in criminal non-death penalty cases. So it's done different ways, different places. My jurisdiction is still 12. And so obviously I feel more comfortable with that, but that's just because that's what I'm used to, really. Erica wants to know if she served any time in jail. I don't think so. I mean, a night or two maybe, but I don't think there's been any substantial amount of jail time. So I am. Please explain the Allen meaning, Marlon-Maastricht asked. There is a Supreme Court case, the Allen case, in which and the issue is this: you've got a jury that's split. A jury that can't agree. Well, if they can't agree, what's going to happen is a hung jury. And if the hung jury happens, then there is going to be a lot of time and effort that's lost. There has been a lot of work by the prosecution. A ton of witnesses have come. There's been a lot of work by the defense. It's expensive for the defense. If it's a case the defense is paying out of pocket, then that's their own money. And if it's a case paid for by the state, it's expensive for the state. So not to mention the court and the judge, all this time, all this effort has gone into this case. And so the charge will say to them, look, don't think that there's some other jury out there that's going to be so much smarter and wiser and they're going to figure it out when you couldn't. Don't think to yourselves that this can be passed off down the line. It's you and it's now. And so you need to figure this out if possible. And it'll be phrased a certain way based on Florida law. I don't know how they'll actually have it phrased, but they'll have a canned statement that they'll rip out and they'll read it to the jury. And it'll say, keep working. Open up your minds. Think of what other people say, consider whether maybe they could be right. It is somewhat controversial because of the idea that, especially if it's a minority and most people feel on the other side, maybe it pushes the minority to give up their view. And the minority would, because does it undermine the idea that it has to be a unanimous jury? Because if it's a unanimous jury, any one person can cause a mistrial by refusing to agree. But if you give the Allen charge and you push them, well, the biggest push comes on the 1 or 2 holdouts, not on the 10 who all agree. In theory, you're telling them all, go back and listen again. But in practical terms, the biggest pressure comes on that small group. What does that mean? It's just controversial. It's controversial for that very reason. So we are, for those of you just joining us, we are waiting for, we don't know what exactly, Godot, I guess, but the jury is out and they refused the opportunity to go home for the night, and they say they can't agree. So what will they do? We are all very, very curious. Can the judge call it a night and order them to reconvene tomorrow? Yes, I believe he could. He obviously didn't want to do that. He said he would give them the option, but I think he absolutely could. And if I were the judge at this stage, I would, because I think it's late. Certainly if they come back, I think he will do that. If they come back and say, we still can't agree, I think they would do that. All right. Favorite lawyer of all time and why? Nick asked me. Abraham Lincoln. Favorite lawyer of all time. As far as why, I just loved some of the quotes from him, what he said about clients and dealing with clients and about not taking positions that you don't agree with and telling clients, no, I don't agree with that. I'm not going to take that. I'm not going to argue it. And I just thought he had so much integrity, and I loved what he wrote about the law and some of the things he said about it. So Abraham Lincoln, that's my answer. Michael Lalonde, is this the longest you've ever spent on a live stream? 100%, Michael. It is definitely the longest. 3 hours, world record for the channel record, and you were here for the big moment. Yes. I don't think I've ever taught this much in my whole life, all in a row. Avalon, I was late to the stream, so I'm not sure what was asked, but how come they're allowed to stay this late? Indeed. Does Florida not have some kind of day limit? Apparently not. Apparently not, Avalon. But they sent out 2 questions. And here's what's happened. They've sent out questions and statements. So here was their first question that they sent out. They asked specifically about Dr. Quintal, one of the witnesses' testimony when the defense recalled him. He was called the first time by the prosecution and then recalled. Here's the question. Was his description about, I wrote with, but about, I guess, or of Doug, the victim, based on his observation or what Ashley told him, i.e. domineering, super controlling, alpha male, over the top, not genuine. And they have exact words. I can't remember specifically over the top, but the rest, they really knew what he had said. And they said they had this question. That suggested immediately that they had people on both sides of the aisle, that they had some people who were looking at what he said and saying, he saw Doug Benefield as domineering, super controlling, alpha male, over the top. That means that Ashley Benefield had the right to defend herself in her own home, and we think that this is self-defense. But it also means that somebody was saying, now, wait a minute. The only reason that he thought that, this doctor who had counseled both of them, was because he mostly met with Ashley and she told him that about Doug. He didn't base that on his own knowledge and information. So that was the dispute between the two. I would assume that's why this was so important. They were trying to figure out, is Doug Benefield the kind of guy who would frighten somebody like Ashley Benefield? Is that a real thing? And so that's what we are anyway, that's what we are waiting to find out. But we knew from early on, this was very early, that they had that kind of question. Now, we got a statement from the jury. Jurors can't, let me see, I wrote that one down too. Jurors can't agree, something like that. Signed jurors. Wow. And the judge said, well, would you like to leave for the day? And they said, no. Unable to come to unanimous verdict. There was dispute or debate. Dispute isn't quite right. Okay, what does the judge do next? He said, would you like to take a break and leave for the day? And they said no. So here we are, 10:13 at night, and they haven't left for the day. They are still back there thinking about it. The next phase will be an Allen charge. And the judge is not going to give that lightly until he's really pushed them. So at some point, I would think he would tell him, you need to come back tomorrow. That's what I would guess. I hope I wasn't frozen. Anyway, okay. So how late can they stay? We do not know. Hey, Mona says, you look great. How are you feeling? I am feeling happy, relaxed, and energetic. I am. I think it was seeing grandbabies. There's just something so life affirming about that. For many of you who have been following the channel, you know that I lost my husband recently, May 8th. Who's counting? But, it was so great to see grandbabies. There's something so life affirming about that. And anyway, that was truly, truly wonderful. Oh, thank you, Kathy. I appreciate the super sticker very much. And I don't know if we welcome Crystal Dawn, who's a new member. I'm so glad about that. And Lee Dundee is also a new member. So glad to have both of you. Glad you're here. So ABC123 wants to know, can you tell us one weakness you found from the prosecution and the defense? One of the things that I think was a shame. Oh, okay. So there's stuff coming across on the screen, but it doesn't seem to be anything specific. So the ABC asked me about a weakness, prosecution and defense. I felt like the prosecution really pulled things together in the end, but I thought more organization might have helped the jury understand a little bit more. And I did feel like they had some problems with the testimony about what exactly happened on the 30th or was going to happen on the 30th. And that was their explanation for Ashley Benefield's motive. That was why she was going to kill him. So according to the prosecution, and they changed what was going to happen on the 30th according to the defense argument. Now, as for the defense, I thought it was a shame they didn't get in the DNA evidence that they wanted to get in. And it took a lot and would have been expensive. I don't even know if they could afford a DNA expert to cover that issue. And that may be what the problem was. They may have felt like they needed it would just cost more than they could cover to pull in a DNA expert. But maybe if there's a hung jury, maybe they'll decide on that next time. The reason the DNA evidence would have been important is because Doug Benefield's DNA, and I'm going to put lots of caveats around this, but it was found on her wrist, I think, and maybe her hand. And she had argued that he grabbed her and tried to push her out. She was trying to leave, and he pulled her back in. He twisted her around, pulled her back in, and then she ran away from him. That's how she ended up in the bedroom and had the gun, and she shot him as he was coming toward her. So DNA on her of him might have been helpful to her case. But it wasn't exactly that they found Doug Benefield's DNA. It was that it was 750,000 times more likely to have come from Doug Benefield plus two other unidentified people. So that made it a little more questionable. And of course, she did have a child with Doug Benefield. So it needed explanation. And the judge said, you don't have anybody here to explain that. The judge also wanted them to show chain of custody. I thought based on a case that the defense pulled out, they might not have to do that. But I think they would have had to have an expert to explain it because it was pretty confusing. Veronica, knock me over with a feather. I am with you, Veronica. Let's talk recipes or crochet. SP. Having seen Mama Pink's crochet, I now feel inadequate to discuss crochet. But you remember I was wearing a wrist splint for quite a long time because of some arthritis right there in the thumb. So I haven't done crochet in a while. I really do miss it. It's a lot of fun. Oh, Loretta, what a good question. Any more info on the YouTube beta function? Okay, well, I've been so busy coming back and working on this case. We have a brand new feature for this channel. There were 20 to 50 channels picked across the entire YouTube platform, and we were one. And it's going to be a discussion group where we can go in and talk about it. I understand some of you have already been on there. I got to do an intro for it. I'm supposed to do a letter to you that will introduce it. YouTube itself is moderating it. So don't think you can get away with anything crazy, because they are themselves on it looking at, what are people saying, and they're pulling people's comments off. It's experimental. They're trying to see, would this be a good idea? Would it help? I think it's going to be a ton of fun. So hopefully tomorrow, one way or the other, I won't have to go back and I won't have to listen to testimony all day or anything like that. So I can really focus on that and get our letter out and really start with that. It's going to be really a lot of fun. We already have such a great community here on the channel. I think that there are some cases that are just super controversial. Karen Reed was one, and this case is another. Nonetheless, our goal has been to be very I try to give you what the facts are and help you understand the case. And then in turn, we ask that people be respectful and kind to each other in the chat, and to understand and appreciate that there are different opinions, and it's the information that helps you reach those good decisions. That's what we're aiming for. And we have had such a great group with people really working on that, and just I just think we have the nicest group. It's just great, folks. Martha says, great bonding moment for community, but does Lee want a break? Yes, the Lands nightgown and bunny slippers. I used to have a Lands nightgown. I always had a Lands nightgown growing up. Yeah, I haven't had one of those for years, but I totally remember those. The little flannel with the little bow right here, remember? Yes, and the smocking that goes around here. Absolutely, or the yoke, I guess it is. But yeah, I totally remember the Lands nightgowns. So very comfy, I might add. Yeah, we did do a hot chocolate night one night where everybody was supposed to bring their hot drink. We talked about a case. It was a lot of fun. So we'll have to do that again. Maybe not hot chocolate in the middle of the summer. I understand in the Netherlands for Marlon, it's been super hot, and uncharacteristically so. It's super hot here, but we're kind of used to it. That's pretty normal around here. Wow. Orion crochets 100+ beanie hats a year for the homeless. Wow, that's amazing. All right. So, and yeah, for those of you who are looking for that beta page we have that I need to get fully set up, but you can already make comments on it, as I understand. So it is under, if you go to my channel itself, so underneath this, there will be Lawyer Lee, and you'll see that's the channel name. You'll click on that, but don't leave yet. We're in the middle of our live stream. But right afterwards, when the jury does whatever it's going to do, click on Lawyer Lee, and it will take you to my channel. And then that's where you'll be able to go into this beta function, beta feature. And it's under construction, so we're the experimental group. But I was really honored to be picked. And the truth is, it really wasn't I'm not the one who got picked. You got picked. They decided that this community and this group was really special and really different, and different enough that they wanted you in this experimental format. And they want to try it. They may roll it out to everybody, but right now they are going to take a maximum of 50 channels across the entire YouTube platform. Can you even imagine how many channels that is? And you were picked as one of those. So congratulations. You deserve it. That's my opinion. So let's see. I'm going to... great. Diane Welsh is a new member. So glad to have you. And we've had think 30 memberships gifted tonight. So be sure you turn it on. YouTube randomly gives these out. We have zero control over it. I don't even know quite how it's done or how they make that decision. So hopefully you will be the one who gets the free membership. All right. So I am. All right. I'm looking for question marks at the beginning. This is group participation here. I'm counting on your questions. All right. Juju, another one. I followed you for Trichonis, and I know you don't want to be biased and would talk about it after the verdict, and I missed that live. What was your opinion of Trichonis? Okay. See, there's the perfect example where I was able to skate around that. I never actually gave my opinion of Trichonis. So I guess since it's just us here, so my opinion was that I did not feel like Michelle Trichonis was guilty. And I say that all the way to not just, I didn't feel like they met their burden of proof. I didn't feel like she was guilty. And let me tell you what I base that on, because it may surprise you. It was, remember how I did little segments of those interviews they did with her. And I went over and over with AI they were so hard to hear. I was trying to get a transcript for you and to put it on the screen while they were speaking back and forth. So I had AI do it. And then I listened over and over to try to get it just right for you. So I listened to those tapes over and over and over again, more than probably anybody except the police, maybe. And that was what convinced me. I just felt like she was really persuasive in her depiction of that. So that was kind of the primary thing. I also then felt that their evidence was weak of her actual involvement. I thought the state's evidence was weak. I was very displeased with the way that there was a bunch of evidence put in there about all these blood-like stains and so forth. And then days later, you would learn that blood-like stain wasn't blood at all. It was something else, and only this was blood. And I felt like that was really confusing. Now, I also blame the defense for that to some degree, because some of that, the defense objected, but there needed to be more explanation for that. All right, so unfortunately, I was nabbed on my opinion. And I say that because I know that that's going to be controversial, but that's just kind of what I came to over that. And I certainly respected the large number of people who have followed the case for years before I followed it, and who really did strongly believe that there was good evidence of her guilt and did believe that she was guilty. Okay, so I am looking for questions, and be sure to put your question. J. Ray, if I haven't asked your question, yes, ask it again. It means that I missed it somewhere in there. JBD, pick me. Ask YouTube. Yes, indeed. YouTube, please pick JBD. They want to be selective. Be sure you've turned on the ability to receive the membership. That has to be, there's some kind of click. Mama Pinks will put it in the chat again that will explain how you do that. There are over 100 million YouTube channels. Look at that. Y'all are 20 or 50. We'll take the big number. You are 50 out of 100 million. There you go. That's you right there. Pretty impressive. All right. Oh, thank you, Esther. I appreciate that. All right, Joy. What happens if a juror can't decide on guilty or not guilty? Does that ever happen? It does. And if the way it works is the jury has to believe, each individual juror has to believe that the state met its burden of proof beyond a reasonable doubt of each of the claims. And if they don't believe that, then the tie goes to the runner, basically. So if they don't believe the state reached its goal beyond a reasonable doubt, which is a pretty strong standard, stronger than the civil standard, if they don't believe that actually happened, then they are supposed to acquit, not decide not guilty. That's what they're supposed to do. And that applies to each and every juror. So if they can't decide between guilty or not guilty, that means the state did not meet its burden of proof. And so it's a not guilty. All right. All right, looking for question marks at the beginning. And then I'm going to go down and see if I can get the one that you were just asking me about, J. Ray. All right, looking for questions, Y'all, this is group participation here. I am counting on your questions. I'm going to go back down the bottom because I know after I gave that Allen charge for the chat, this is the dynamite charge for the chat. Questions, please. All right, so dynamite charge for the chat. You have to ask questions. There's just a rule. Oh, favorite judge from all the cases you've covered, ABC. Good questions tonight. Okay, so favorite judge, I think would maybe be this one. I really liked this judge. I just really felt like he was so scholarly, that he was really steeped in the cases, so serious about getting to the right decision, explaining it to both sides. I think he is a great judge. I bet he almost never gets reversed because he's a great judge. So why would Ashley go through the trouble of packing for the move if this whole thing was premeditated? I thought that too, Dahlia Lynn. I thought that as well. Dahlia Lynn, there we go. I thought that too. It seemed like a lot of work to do. If the only intent was to move to Maryland, then you would pack. But boy, to pack when all you want to do is shoot him, but why not just have him over for something and say he attacked you? I felt like she at least had to have been contemplating moving to Maryland, right? Has to have been at least considered. So Arizona Amy wants to know about if I had a Chico's red shirt on. Yes, I did last night. Yes, I did. That was, wow, good eye. Good eye. Yes, that was a Chico's red shirt. Okay, Nick, she was in the car helping him throw out the evidence. How do you get around that? Oh, we're with Troconis now. Okay. I was like, what? Ashley Benefield was in her car. Oh, we're on Troconis. So, okay, she was in the car. She says she had no idea he was throwing out anything. And I didn't really feel like there was any strong evidence that she knew. Now, we've got people walking around in the courtroom. I can show you. It doesn't really mean anything. It just means that probably they're going to get started on something. We're probably about to hear from the jury again. Okay. All right. Let's have a 1, 2, 3 poll. I'm going to pull that out. So, okay. 1 means you think they have a verdict of guilty. 2 means you think they have a verdict of not guilty. And 3 means you don't think they have a verdict. Okay, so 1, guilty, 2, not guilty, 3, they don't have a verdict. And it could just mean they're going to come back and say, yeah, we can't do it tonight. Or that we can't decide and hope the judge is going to dismiss them. They are wrong on that. They are incorrect. They do not know about the Allen charge. That would be my prediction, and they will be unpleasantly surprised if that's what they're hoping for. So we're probably on the 10-minute call. So these are the first people to come back, but and I'll put it up in just a second. All right. I missed it. What are we 50 out of a million for? Janet stuttered. Probably many things, Janet. But in this particular case, what you are, the chat and the community is 50 out of 100 million of YouTube channels, because we've been asked to be in the 50 maximum channels that are being picked for a community chat. It's not something that is being done. I'm going to turn this up so if there's any sound or anything, ooh, a lot of police coming in. I'm going to go ahead and put that on the stage so you can see. And maybe they always do, and I'm not always in at this particular time. I'm going to pull that out so you can see that a little better. Welcome, Diane. We are glad to have you as a new member. And okay, so we were talking about the beta community. So they are picking 50 communities, and these communities are going to be given a special chat. We've already been given our special chat. So I just kind of have to go and write you a welcome letter and kind of begin to unfold it and decide how we're going to use it. So we'll be incorporating that. And that's a great way for me to get your opinions and your thoughts in, but it's a way you can chat with each other. So this is different from just making a chat. During the chat, you can talk back and forth. But when you make a comment on a YouTube video, people can see it, but you can't talk back and forth. And this is a way to continue the chat outside our live stream. You can keep going if you want to. It is moderated by YouTube to prevent any kind of abuse on that. They themselves monitor it. I don't know exactly how they do it, but whatever you do, don't do anything cray-cray. So, but that's what they're doing. It is not for members only. I see Ms. VG3 asking. It is available for anyone in the lawyerly community. Probably you have to be a member. We're just going to say that. Yeah, that's it. You have to be a member. Speaking of which, not a member. I mean a subscriber. So if you're not a subscriber, this is the perfect time to subscribe. And by the way, please hit the like button. If you've stuck with us all this time, by all means, hit the like button. Could the judge decide to send them home without another note? The judge could do that. And if I were the judge, that's what I would do. I would say, we're coming back tomorrow, because I think the judge has that kind of authority to do that. But he obviously didn't choose to do that. He didn't want to do that. He wanted them to be able to have that control and be able to make the decision. I think, though, he was as surprised as I was that they didn't decide to go home before. So we will see whether they have an actual verdict or what's going on. So, and I don't know the answer to that yet. Let's see what SoCo Judy says. Do you think the jury will be really mad when they come back and get the Allen charge? Yes, I do. And I think most juries are, but it will be even worse because it's 10:34 at night. And so they are thinking, we tell the judge no again, and the judge is going to let us go. And that is not what's going to happen. And it may not even be what does happen. And I see JBD asking, what time is it for the trial? It is 10:35 p.m. at night. This is in Florida, and they are on Eastern time, at least I think. All right, so I'm looking for the questions as we wait. But yes, I think the jury would be mad, SoCo Judy. All right, who is taking care of Emerson? I don't know. Emerson, the child of Doug and Ashley Benefield. Least favorite judge, Winona. Not going to go there. Not going to go there. But interesting question. Hey, how about that? You put your least favorite judge in the chat just for fun. And I'll see I'm curious what y'all think. But I'm not going to do that. YouTube directions for the new experimental feature. And so when watching a video, ask appears. Oh, that is a good point, because that feature, ironically, is only available if you're watching by phone. Our new chat group, I think, is phone only and not on your computer, which is very ironic, is it not? Since we aren't allowed to join the channel from the phone, only from the computer. So I don't know. These two groups are not talking, right? Somebody needs to get together. So I've appealed the fact that we don't have the ability to join from the phone. Some other channels do, but not ours. So maybe we'll get selected for that special group at some point. Hey, Mona is asking me, and we'll probably have to stop in a minute. What was it like applying to, being accepted at, and graduating from Harvard? It was truly a life-changing experience. When you go to Harvard, you are in a group of really smart people from all over. So you are learning so much from the other people there. It was just an incredible experience because they were from all over, not just the country, but there were people from all over the world in the LLM program. And they just taught me a ton. I learned a lot of things about the way people thought and other ways of thinking, and just the ability to apply that in a legal setting. It was phenomenal. It was really an amazing experience. It was not the cutthroat that you picture from if you've ever read 1L or some of those books. It wasn't like that. It was in fact very people worked together. I think everyone was pretty sure that when they left, they were going to get a good job somewhere. And so nobody was particularly worried about that. And they didn't feel the same sense of competition that they might have if it was a life or death job or no job sort of situation. I felt like it was really an unbelievable experience. I was so grateful to have gotten to have done that. I really, really enjoyed it. Now, there's no sound yet, so it should show up. I'll hear it from 2 places, and then I'll turn off the phone here, but I'll have my check. Rhonda asked me, if it's a hung jury, do you think they will have another trial? Is that decided by the state? It is decided by the state. The state might say, we don't want to pursue this again. We couldn't get a verdict, and we did the best we could. And evidently, we just can't persuade a jury. Or they could say, we're going to try it again. And we've seen with Katie Medbanawa in the Charlie Adelson saga for the Dan Markel murder, they tried her again, and she was convicted the second time. Hung jury the first time, convicted the second time. With Karen Reed, the prosecution has announced they are going to do, no sound yet, but the prosecution has announced that they are going to do another trial. But there's some question. The defense is pushing for no new trial, or at least eliminating 2 charges where they believe the jury had reached a conclusion and they weren't allowed to inform the court of that. So we did it. We've done some videos on that, and we will watch that play out. What do you think you will cover next trial-wise? RV there yet? I like that. What will I cover next? I have here's Ashley Benefield coming in. So that is definitely what they were waiting for. I would expect sound pretty soon, as soon as they get settled. So, and I do want to talk about what we'll cover next, but I don't want to talk over them. There are several cases that are hugely interesting, I think. Here we go, sound.
All right, we're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I've been informed there's a verdict. Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately.
She looks sick. This is Ashley Benefield.
I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact, our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected, even if you don't understand it or don't agree with it. Are you ready to bring in the jury?
Yes, sir.
All right, bring them in.
Again, gobsmacked twice in one night. Wow. A verdict at 10:41 at night. Ashley Benefield does look really sick. April, I'm so nervous you'd think I was on trial. Yes, I'm nervous too. I'm wondering. So I saw a comment that from me saying a fast verdict usually means guilty. That is sort of a rule of thumb, is that a fast verdict typically means that. I don't know here. They obviously were divided from the beginning, and then they told us they couldn't reach an agreement and then they went back. So it must have been not very
Members
deeply
of the jury, I
divided.
understand you have a verdict and we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form.
Very nerve-wracking.
All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in for Manatee County, Florida, the state of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense.
Oh,
Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl, foreperson.
Would either side like the jury polled? State? No. Defendants?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices, and please make sure that your notes stay with the deputy. They're going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you. All right, you all can have a seat. The jury is out.
Wow. Wow.
State.
Judge, I would ask you to remand the defendant at this point. I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do you went to PSI?
Pre-sentencing investigation, I think.
I
is
think
what they're
we
talking about.
prefer to have PSI.
I'll sign an order tonight for that. It's a late in the evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that Younghans, rather, I know that the court is familiar with the standard. They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benefield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here, her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghans decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Ms. Benefield to bond, continue her on the same bond, in fact. And if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the second district. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny bond.
Any rebuttal?
No, sir.
Ms. Benefield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff.
Wow.
We're going to revoke your bonds where you'll be held pending sentencing.
Wow. So she's going to jail right this minute. Like now. Like that lunch I talked about, it was her next to last meal outside of prison for a long time. Even if post-appeal bond is granted, it's going to be a while. So. And it probably won't be granted either. We've already talked about that appeal. Wow. Wow, and I agree. Somebody said she was writing a note to her daughter. That's what I figured too. Wow. Wow.
Sorry, the court has stayed in recess until we get a sentencing hearing set up.
Thank you, Your Honor.
I trust Your Honor will issue a written order on the bond.
The bond?
Yes.
Yes.
Yeah, now we know why the cops were in the courtroom, but that probably would be the case anytime you have a
If it's
verdict,
required, I certainly will.
because they might be needed.
Thank you, Your Honor. Thank you, Madam Clerk. Thanks, thank you.
Wow. Well, that was something. Okay, so we now have the answer. Eva Benefield did not seem happy with that. She is Doug Benefield's daughter, the one who was surprised to learn from him that he had married her stepmother, Ashley Benefield. So that is the end of it. Let's go ahead and pull that out. So it was not the worst possible verdict for Ashley Benefield, but it was a lengthy prison sentence coming down the pike unless she succeeds on an appeal or her bond. Here's what the jury was to decide. They were supposed to decide one of three things: guilty of murder in the second degree, guilty of manslaughter, or not guilty. And they picked guilty of manslaughter. I saw some people ask, was it a compromise verdict? There's no way to know. And unless they reveal, there's no way we will ever know. But all members of the jury agreed that beyond a reasonable doubt, the state had proven she was guilty of manslaughter. So there were enhancements on that, and they answered all of them yes. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging the firearm, cause death to Douglas Benefield? Yes. So those will force the judge to impose a mandatory sentence. I'm not sure what that will be. When I looked it up in the mandatory minimum statute, I didn't see manslaughter listed for enhancement. For murder in the second degree, it would have been a minimum mandatory from what I saw of 25 years with a maximum of life in prison. Manslaughter, obviously, significantly less than that. I saw someone in the chat say 9.5 years is the mandatory. That could be, I don't know for sure. 15 is what I saw as the maximum for manslaughter. I don't know if that changes with the firearm enhancement, but that's a special provision under Florida law that says if you have a firearm when you commit this crime, it's going to be enhanced and it will be higher sentence. In fact, the way it works, I think, is there's a mandatory minimum. The judge isn't allowed to go less than that, and then it can go up to the maximum. So that would be a better way to phrase it. I think many people are exactly what the judge said, unhappy with that. I think people who felt strongly that she was guilty will think that wasn't strong enough. She was guilty, in their opinion, of murder in the second degree. People who felt she was not guilty will say, this is unjust. She's going to spend a decade or more in prison away from her daughter. As her daughter grows up, she will not see her daughter for most of her growing up years, and that's unjust. So both sides, I think, will be unhappy. I think that's probably why Eva Benefield was crying, I imagine she wasn't happy with this verdict. She didn't feel like it was enough. There was very little reaction from Ashley Benefield. I mean, you could tell as she was waiting, she seemed ill, but she's shown very little emotion, very passive throughout this, and she really continued that. So I am I am curious, what y'all think. I'll put out a poll tomorrow and see what you thought. And I'm curious what you've been thinking about this as you followed along with it. And I'm not surprised. Second guilty of murder in the second degree was a strong showing for the state. That would have been, especially difficult to prove. We saw that the jury was split. I guess what surprises me the most about this verdict is that there is one. And the reason I say that is because they came back initially and they said, we don't agree. Well, they asked that question that suggested they had disagreement. Then they came back and they said, we don't agree. And then they wouldn't leave. They wouldn't go home. You have to give them some credit for hanging in there. And it must have been split pretty heavily toward guilty and pretty lightly toward not guilty, but there clearly was some disagreement. And they ended up with the guilty of manslaughter, whether by whatever means they reached that. They all had to agree that beyond a reasonable doubt, the state met their burden of proof on manslaughter. And that is what the verdict was. So thank you for hanging with me. The longest live stream in the history of the channel. And I really appreciate your being here. And I will look forward to seeing you all. We will still go tomorrow night at 7 p.m. at our customary time. I want to cover the defense and what their closing argument was. And I especially want to do that now that we have the verdict, because I want to talk about what are some of the things that may have brought the jury to manslaughter instead of murder in the second degree. And I want to talk about what the defense said. I thought it was a very strong closing argument. And I don't want to only cover the prosecution. I also want to cover the defense because I do think it's very important and raise important issues about self-defense. So thank you so much for being here. Is there anyone I haven't? Oh, thank you, Matt. Matthew Pitzinger, gifting 5 more lawyerly memberships. That's twice tonight. And you did 20 the first time. I'm very appreciative. Thank you for doing that very much. And I look forward to seeing you all tomorrow night at 7 p.m. And we will talk some more about it. And be sure to head over to our special beta chat over there under the community page. You have to do it with your phone, but head over there and you can make comments about the trial and what you thought about it. And I will see you over there. I no longer have, since